May I please your lordship? Similar matter was on.
एमती केतेटा आपनकर अछि
Sorry, my lord.
जा ओके हां हां
Item 2, item 2, 1 2. The order to 1 and 2 by.
1 and 2 dita acha ei dita hi salla tal tangara
Again.
already.
Item 3.
The appellant has challenged the impugned judgment that is truth in passed in CP number 162.
सर माइक्रोफोन टा आपनकर मुहर रहबे ना आपनकर
ଏଇଟା ଟିକେ କାଇଁ ପଢୁନାହାନ୍ତି କଣ କଲ ଲିଷ୍ଟ କୁ
आउरी बेंड कर दिन तळକୁ स्टेम टा आउरी तळକୁ बेंड करन बेस टा बेंड करले हो
The appellant in present matter 6 challenge the impugned judgment dated 2/3/2023 passed in CP number 162
ପୁଣି
19
ଶୁଣ ସେଗୁଡା କିଛି କହିବା ଦରକାର ନାହିଁ
my lord.
ତାରିଖ ପାସ୍ ବାଇ ସୋ ଏଣ୍ଡ ସୋ
ମାନେ-
ସିଟିଂ ଆଟ୍ ସୋ ଏଣ୍ଡ ସୋ ଏଗୁଡା କାଇଁ ସବୁ ମେନସନ କରୁଛନ୍ତି
My lord,
so
6
this is a wife has come here
husband.
husband has come
Yes.
Suchitra
Oh,
Mutili
oh,
acha
oh.
husband has come
Yes.
so
Three
the
times.
CP was moved by husband CP was moved by the husband and CP was 13-1
31
rejected
rejected.
that's all one sentence husband has come having his 13-1 application being rejected by the trial
My lord.
or family court that's all what was your ground
My
with the
lord,
13-1
two grounds. One is desertion, other is no physical relationships between the appellant and the opposite party during.
satisfy
My
the
lord,
condition
three
and
times.
desertion there is no 2 years desertion
My lord, last 3 occasions amicable settlement was made. She refused to.
oh, you are not answering the query of the court what is the question put by the court
Desertion. Desertion.
have you satisfied the question of desertion the conditions in desertion
2 years before.
2 years before the institution of the proceeding
Yes.
or not
Yes. Yes.
so heichi ki 2 years heichi
No, 2 years.
adare desertion ta ku apun kai press karibe you should make up your mind
Yes,
when
yes.
placing a case you should make up your mind
Yes, ma'am.
13 ka 13
आपण जो ग्राउंड गुडा को नैथिले लोअर कोर्ट रे 13 रो को प्रोविजन को देखि नैथिले
13-1 नेथि desertion and physical
Yes,
relationship.
कोठी अछि आगा 13-1 फिजिकल टा
My lord,
13-1 रे फिजिकल टा आपण कोट पाइले
of course have you filed the certified copy
Yes, my lord.
it is there right you are an employee in India
My lord, wife employment place is Bengaluru. Husband's place is also Bengaluru.
who is residing at America
Wife. On deputation, she has been to US.
that becomes a ground for
Desertion. And it is
cruelty
cruelty and desertion. And while she is in
wife
US,
has come
wife has come, my lord.
admit for you all right admit call for LCR in CP number refugees as undertaken by 3 working days there shall be miscase there shall be stay of operation of the judgment dated 5/8/23 in CP 65 of 22 till final outcome of the appeal.
Obliged, my lord. My lord, may I take notice in both his permanent address as well as the present address, my lord? 2 sets of requisites I will file, my lord.
Okay, considering the request of the learned counsel for the appellant that to avoid any conflict in the service of notice on the respondent, the appellant here desires to take out notice on both the addresses available of the husband available. This court permit taking out notice on both the addresses. Requisites accordingly be filed in both addresses. Please.
Grateful, my lord.
ତାମାନେ ସେ
ଏବେ କିଛି ଦିନ କରୁଛି ମୁଁ I'll be there in the court, my lords.
Okay, ଦେଖିବା, all right. Argue, what is this matter?
My lord, annexure 10 is under challenge.
Right.
Annexure 10 at page 55, my lords. Here, my lords, demand was raised, conciliation is to be taken up. Conciliation was not taken up. I approached this honorable court. This honorable court directed by the annexure 3 for taking up conciliation. Conciliation was done. Annexure 4.
What is your ground? You are challenging a reference only.
My lords, here, my lord, all the dispute has not been referred. No reason has been assigned. For non-referring, your lordship knows, my lord, section 12(5) says that if the government is not satisfied to make a reference of the disputes, my lord, then
So come to your complaint. What
My
are
lord.
the what are the issues you raised?
annexure 2, my lords. Annexure 2, page 24,
Yes, 24. These are all the demands.
my lords. Out
Now,
of 7,
where is the failure report?
annexure 4,
Acha, just
Pursuant-
make it clear from the demand page 24.
my lords.
What are the issue? Those have been referred.
Yes, my lord. Your lordship may
Serial
kindly
number.
come.
Serial
My
number.
lord, serial number 1 of the demand has not been referred.
What are the issues referred?
My lord, issues referred annexure 10, whether the workman, non-executive employee
Oh,
of
that is readable. There is no issue. From
Right.
out of your demand, what are the issues referred?
Acha, that my lords, say 3, and my lords, the management OHPC immediately revised the 3, 5. These main dispute has not been. My main dispute is annexure.
No,
I mean,
five ହେଇଛି.
again.
5 ହେଇଛି can a revision of wages ଅଛି
Yes,
ଏଥିରେ.
yes, yes.
Okay. And
Again.
allowances with effect. Allowances କୋଉଠି ଆପଣ ଆଣିଛନ୍ତି?
Allowances ଅଛି ଏଥିରେ ଏଇ 3 ରେ immediately revise the allowance structure of OHPC.
Item
3.
3. Okay, revise allowances structure.
ଆଜ୍ଞା ସେଟା
So,
ଅଛି.
ଶୁଣନ୍ତୁ ଟିକେ go slow, Mr. Mishra.
ଆଜ୍ଞା,
Yes, 3 and 5 are already covered in the reference number 2.
my lords.
Okay. Now let us see what is referred under reference number 1. Employees of different units of OHSC are entitled to benefit of remote area allowance, special allowance,
Again,
hydro allowance, shift allowance.
again that
This
that is
comes
complete.
with what?
That annex, that,
Oh, then again item 3.
yes.
Then again item 3.
So item
So
1.
4 also there, revision wages.
Yes.
4 is already referred.
3, 4, 5 referred.
So 3, 4, 5 referred.
Whereas that annex 7 and 1.
7 and 1 are your concern.
My lord. And one dispute was in the conciliation stage, it was dropped. That is admitted, my lord. I mean, it is there in the conciliation report. One demand was dropped.
So let us, you satisfy us. One is coming within the items in the schedule.
My lord, schedule name
required to have industrial adjudication.
Yes, that is why I have annexed Annex 12. That is why on the last occasion, my lords posed that question, annex that schedule 3 and all those things. That is why I have annexed annexure 12, my lords.
Annexure 12.
Yes, my lord. It is an industrial dispute has been referred pertaining to regulation, my lords.
Page kete?
Page, my lords, this is 59. And that is the sole dispute, main dispute, my lords. That is the thing. And no reason has been assigned.
No. This is annexure 12 is another reference.
Yes. Another reference, not concerned with this case. I have given this.
No, we are not there, Mr. Mishra. You are not picking up the question.
My lords.
Question is, there are schedule items which are to be referred for industrial adjudication. This is, so therefore come to schedule, satisfy that this is a matter required to be referred.
Yes, schedule 3 does not speak about this, but schedule 3, my lords, is not exhaustive.
Just 1 minute, let us see schedule 3 idea.
My lords.
After the statutory provisions, there are schedules. It is section 10 part. Schedule 3.
My lords, third schedule.
Is the capital Roman 3. Third schedule.
Again.
Yes, third schedule, read. Where is the issue of regulation there?
That is not there, my lords. In
If
category.
it is not there, then it need not be referred.
My lords, that is
not be referred.
My submission is, my lords, this schedule.
No, annexure 2, there is somewhere some reference doesn't bind us.
No, that is all right. I'm not saying that. What I'm saying, my lords, annex this schedule 3 is illustrative. It is not exhaustive. That is my submission.
Then you have to challenge the schedule. You have to challenge the schedule.
On the last occasion, my lords, your lordship
said.
No,
sorry. Forget. Then come to item 7.
7,
come
my
to
lords.
item 7 again. Find out if item 7 also comes within that.
It is a condition of service, my lords. My lords.
No. Uniform pension scheme should be. So which part covers?
My lord, the industrial dispute definition covers any dispute pertaining to employer and employee relating to conditions, terms of employment, condition of service, all those things.
Yes.
So, condition of service, it is coming, my lords. So, and there is no whisper about.
OSPC has a pension scheme or not?
No, my lords, not for these employees. For these employees, they are not giving, my lords.
No. If at all, OSPC, if at all has a pension scheme.
Yes, it has. But we are getting only that EPF, my lords, your lordship knows.
Then why you want industrial? You can very well bring a read petition. You can straightway come in a read petition, sir. Yes, there is discrimination amongst the employees. Why industrial education? No, Mr. Mishra, question is, you are industrial expert. I know. Long practice in the industrial adjudication area. So therefore, make an answer whether such a simple issue can be answered in a 226 or not.
My lords,
There
we
is no
had
question
approved,
of evidence. There is
we
no
had-
question of evidence.
we had approached this honorable court relating to this benefit, my lords. This honorable court directed the management to consider the repetition, and that repetition was dismissed. So how many times this workman will
No,
come?
no, that's not the issue. That's not the issue. You can come again.
My
You
lords.
can come again. So we approve this reference. Find out other options.
No, I'm saying, my lord, this annexure 10 is a non-speaking order. He has not given because the section
No,
12.
we are not satisfied, right? You may be alleging that is non-speaking.
Yes.
On entering into queries and clarifications, we are satisfied that yes, this
That
need
way-
not be
that way-
deferred.
That way your lordship may dispose of.
At the submission of Sri Mishra, learned counsel appearing for the petitioner.
Seven can be raised in a writ petition and one cannot be
No,
referred.
you leave it to us. We have to take a decision. Don't guide us.
No,
Otherwise,
I'm not.
you could have. Otherwise, Mr. Mishra, we have given sufficient indication. Wise man would have. I don't say you are unwise.
No, I'm
But
not
wise
there.
man would have
I want an
simply
order.
sought for withdrawal to pursue remedies in respect of these issues. You are
No,
leaving to us. We will give answer.
My lord may do that. My lords may kindly do that.
Yes. The writ petition involves the following prayer. Taking this court today, this is a matter decided at admission stage. Okay. Taking this court today, reference at annexure 10, reading together with the demand of the union involved herein, the petitioner. Running page 24, annexure 2. Sri Mishra brings an allegation that even though the union raised demands on several aspects, thereby raising seven demands altogether, failure report failure in absence of any reason assigned in the non-recommendation of some issues for reference, there has been abrupt dropping of the issues, particularly by issue number, demands, particularly demand number 1 and 7. In making the reference by the competent authority dated 8/2/23 by annexure 10. In the comparison of the demands and the reference, okay, this court, if for better appreciation of submission, it is in this circumstance and for there has been several demands and demand number 1 and 7 not being included in the reference order, the union petitioner herein alleges there has been illegal dropping of some demands. Unless demand by serial number 1 and 7 are also referred, there is serious prejudice to the workmen involved therein. In his attempt, a reference of third schedule in the Industrial Dispute Act 1947 was also placed on record, and in the process, Mishra advanced his submission to substantiate that there has been illegal and erroneous dropping of the demands by item number 1 and 7. There is, however, clear statement that majority of the other issues have already been referred for industrial adjudication by the industrial adjudicator. And the concern of the workmen, the union herein, involving only on demand number 1 and 7 presently. State Council, who is there? Mr. SAHOO, Leonard, State Council appearing for the authority making reference in the satisfaction of the order of reference, taking this court to the failure report, reading through the same, and again in reference to the third schedule, making way for reference, making way giving particular aspects to be brought under reference for industrial adjudication. Contended there has been no illegal dropping. The statement is submission also advanced by State Council that considering the demand at Annex 1 and 7,
7.
so far as demand Annex 1, it is contended there is looking to the third schedule provision. There is no provision for making such reference. So far as demand number 7 is concerned, it is contended. Demand number 7 also doesn't come under the purview of the third schedule of the Industrial Dispute Act. And at the same time, the employees affected, workmen affected are not precluded from agitating such issue by way of other provisions. It is in this circumstance State Council requested for rejecting the writ application. Considering the rival contentions of the parties, this court find for better appreciation of the proceeding, this court likes to take down the demand raised by the petitioner herein, which remain as follows. Page 24 demand udaka. Okay. Coming to the reference, coming to the failure report, page 30. This court find the competent authority. Okay, this read the previously we astile apna High Court ko.
Again.
Eita astile.
हाँ आस्तिले आपण annex 11 टा सेट पे annex करिछु.
Okay, right. No, annex 5 na.
नहीं मु तो 3 थर हाई कोर्ट आछि. रेफर
No, eita re astile ki.
कोटा रे.
A demand ta not being considered for reference.
Yes. Your lordship
Seta annex 5.
Annexure 11. Seta annexure 11. That is why in the first I submitted in second round of litigation.
Okay, that is annexure 11, right?
My lord.
All right. In the first round of litigation, a reference not being made.
Same view were expressed by your lordship.
Okay. This court in disposal of WPC 7135 of 2023, it resettled haba. Talo kare jauchi, mato dekheba draft kari. Disposal of the WPC 7135 of 23 directed as follows. It appears following the aforesaid writ court direction, there has been consideration of the demand raised by the petitioner herein, and it followed with a failure report submitted by the competent authority.
It's not correct. It's not correct. Annexure 11 पर एटा है नहीं.
How?
नहीं sir, I am submitting my lords. Your lordship may kindly see conciliation demand was raised, no conciliation was held. Then I approach this honorable court. Annexure 3 was passed. Annexure 3, your lordship may kindly see this honorable court directed to take up conciliation, and accordingly conciliation was made.
Hmm.
Conciliation failure report submitted, no reference. I had to approach this honorable court. Annexure 5. Then my lord, this honorable court directed to
ସେଇଟା ତ କହିଲି ମୁଁ ଆନେଶ୍ଵର 5 କହିଲେ ଆପଣ ମତେ ନେଇଗଲେ ଆନେଶ୍ଵର 11 କୁ।
ମୁଁ କହିଲି ଆପଣ କହିଲେ ଆଉ ଏ ମୁଁ 3 ଥର
ହଁ।
ଆସିଛି ଆଜ୍ଞା।
ଠିକ ଅଛି ଦିଥର ସେକେଣ୍ଡ ଟା କୋଉ ଷ୍ଟେଜ ରେ ଆସିଲେ?
Sir, first conciliation failure report, conciliation was not taken up. I approached this honorable court.
Annexure 5 was the decision.
No. Annexure 3. Annexure 3, your lordship may kindly see.
Right, annexure 3 was the decision.
Yes, then conciliation was held. Failure
Hmm.
report was submitted, not
Hmm.
referred. Annexure 5, again this honorable court. Annexure 5.
Annexure 5 page.
Page, my lord, I am coming. Page
36.
36, yes.
Yes, then
Then, my lords, 12.5 was exercised and a reference order was made by annexure 6. And your lordship may kindly see peculiarly, I have never seen such a reference order, no schedule. The
then
reference was
what is annexure 11? Sorry, the page 58 order. 11.
11, sir. On the last occasion on 1/5/2023, this matter was taken up, and your lordship said that this regulation matter is not coming under third schedule of the Industrial Dispute Act.
So therefore, why have you come again then against that?
Because of annexure 12. I said, my lord, several matters of
No,
regulation.
several matter is reference is made that doesn't make a right to you. You have withdrawn. So therefore,
Your-
that issue is already decided in a high court.
No, because your lordship, that was not indicated in the order. Your
Oh,
lordship.
okay, we indicate now. We
Now,
indicate now.
my lord, only your
All
lordship.
right, all right. I understood now. Yes, yes.
Refer to annexure 12.
Okay, all right. In the first এই যে round of litigation টা করলো, এটা হচ্ছে
Otherwise, I-
327,951 as a first step, it is সেটা কাটি দিও না পুরা take out that portion. তা উপরে भी যেটা reference আছে সেটা take out. Reference भी কাটি দিও। ହେଲା demand পরে, so it is at this stage of the matter this court find as a first step, petitioner moved this court in WPC 27951 of 21.
21.
This writ petition was decided by a division bench with the following order. Page 28. ଏଥିରେ କହିଲେ ଯେ conciliation notice ଦେଇକିରି conciliation notice ଦେଇକିରି okay, it appears pursuant to the above direction. The conciliation proceeding commenced as an outcome by the conciliation report dated, failure report dated, as a consequence of the above direction, conciliation failure report under section 12(4) of the Industrial Dispute Act was made.
On 11/2/22.
Okay, this court on perusal of the failure report finds there has been threadbare discussion on each of the demand raised by the union involved within. And finally, the conciliating officer gave the following request. He gave the following direction. Well, okay, finding no settlement could be reached, submitted the failure report before the government for necessary action. Okay, it is at this stage it appears petitioner again moved this court
As no reference was made.
by WPC 7682 of 2022. This writ petition involved inaction of the competent authority in taking any action, decision, even after receiving the considered failure report. This writ petition was disposed of by the coordinate bench of this court by its order dated 13/4/22 with the following order. Page 36 and 37.
Then pursuant to that, my lords, this a reference was made, annexure 6.
Yes, following the aforesaid direction, it appears there has been reference
But no schedule,
of.
peculiar.
Okay, right. Don't
No, no,
have any committee. We are following. If you commit
Sir.
any mistake, then you may interrupt at the end.
sir.
Yes, which order was considered, and as an outcome, there appears there has been a reference order dated 7/5/22 by Dynasty 6. It is unfortunate to note here that what's it called?
Next one.
Mission of Sri Mishra here, this court, that there has been no reference, no indication on reference.
No,
This
no, no.
There's no indication of reference.
Again.
This court on perusal of the referral order finds the referring authority in clear term indicated therein that as follows, inverted comma, and whereas the said government consider it expedient to refer for adjudication the matter specified in the schedule appended hereto which appear to be the matter in dispute. Page 38 রয়েছে তা? ଯୋଉଟା ହେଲା 7/5/22 while the matter stood thus, it appears there has been another writ application moved to this court by the union itself by WPC 30158 of 2022. Making specific allegation on the referral order having no indication on the subject of reference. It is considering such allegation a coordinate bench of this court in the disposal of WPC 30158 of 2022 came to observe as follows. Like Annexure 9, page 51 ରୁ ଅଛି, page 54 ଯାଏ. Okay, quote karo, tapar lekha. This court in its satisfaction that the order dated 7/5/22 is an order of no consequence. This court therefore setting aside the order of reference Annexure 6, dated 7/5/22, Annexure 6, directed the opposite party number 1 to pass appropriate order of reference. Mr. Sahu, take your seat. Order of reference. Within 3 weeks from the date of receipt of copy of communication, it is as an outcome. There is order of reference brought by the competent authority by Annexure 10. Schedule therein appears to be as follows. Page 55. It appears again at this stage of the matter, there has been presentation of another writ application by the union by WPC 7135 of 23. এই রিপিটিশন কপিটা মতো দেখিয়ে বলা বাবু। Considering the allegations therein, this court, by order dated 1/5/23, on the request of the counsel for the petitioner to pursue other remedies available, permitted the petitioner to withdraw the writ application. In the course of submission, question on demand number 1. And even though this court gave the liberty to the petitioner to pursue other remedy, but the orders did not disclose the same. We appreciate Mr. Mishra's information to the court involving the subject involving such writ application, and find there can't be no entertainment of any further writ application on the demand number 1.
And Annexure 12 may kindly be indicated.
It is at this stage, considering further submission of Sri Somnath Mishra through Annexure 12, that there has been reference on similar subjects, though involving other establishments.
Right.
And inference has been drawn through the same by the counsel for the petitioner. This court, on perusal of the 3rd schedule, doesn't find coverage of any such demand in the 3rd schedule. Further, once such issue is already undertaken, consideration on such issue is undertaken and decided by it. Disposal of writ petition WPC 7135 of 23. This court cannot sit over its own order in the entertainment of a further writ application. Coming to the demand number 7, this court find there is attempt of Sir Somnath Mishra to bring the demand number 7 to the fold of 3rd schedule.
No, 3rd schedule. 2K, industrial dispute.
Industrial
said-
dispute, okay, in
Yes.
the under the provisions of
2K.
definition 2K. This court here finds the definition section 2K reads as follows. Quote karba. Reading the aforesaid, even though this court find industrial dispute include any dispute or difference between the employers and employees, between employers and workmen, or between workmen and workmen, which is connected with the employment or non-employment. Looking to the demand number 7.
Or the terms of employment.
Oh, right. This court find the demand under Annexure 7 being considered.
Sir, annexure 7 में सेटा sir serial
Sorry,
number 7.
demand item 7, please ଟିକେ ରୁହନ୍ତୁ ଆମେ correct କରିବୁ ବ୍ୟସ୍ତ ହୁଅନ୍ତୁନି ଆପଣ।
Sir ମୁଁ କହୁଛି ଭୁଲ ହେଇଯିବ ବୋଲି ସେଇଥିପାଇଁ କହିଲି।
ଆମେ କରିବୁ ଆଜ୍ଞା ସିଏ ନେଇଯିବେଣି ଠିକ ସେ ନେଇ ସାରିବେଣି।
Sir, I am sorry.
ତ ଆପଣ ଯଦି ଏମିତି ଇଣ୍ଟରପ୍ଟ କରିବେ କେମିତି ହବ?
No, I am deeply aware.
ରୁହନ୍ତୁ ଧୈର୍ଯ୍ୟ ଧରନ୍ତୁ।
ନାଇଁ ମୁଁ କହୁଛି ଆପଣ ମାନେ କିଛି type of mistake ନ ହଉ, that is my endeavor, not that to guide your lordship.
One query, Mr. Mishra, just guide in 7A, where does it refer to 2K?
Again?
7-capital A, where does it refer to 2K?
I say that it is a terms of employment, condition of service.
Sir, that point is well taken. That is how the question.
My lords.
But
I am saying.
But no, kindly appreciate the question. 7A makes it clear that it has to be third schedule. But you are trying to by argument, I mean develop an argument that 7A also refers to 2K. Where does it refer?
No. It starts from 2K. Everything starts from 2K.
2K industrial dispute is defined, but 7A is a statutory reference.
This court here looking to the third schedule finds this is a provision emanated through section 7 capital A of the ID Act, dealing with a reference to tribunals dependent on the subjects in the third schedule. Third schedule which doesn't include the item number 7. This could find the justification in not making reference of the same demand under item 7. Okay, it is in the above view of the matter. This court find there is no illegality in the reference. In the reference order 8223, it appears even though the matter is already involved in several round litigations. This court here likes to observe in the event petitioner was not satisfied with the order of reference, particularly keeping in view with regard to non-reference on the demand of the petitioner by item 1 and 7. Nothing prevented the petitioner to proceed with the industrial adjudication and simultaneously moving the writ application. As on further consideration, there could have been additional reference orders in the event the petitioner would have succeeded in the read court attempts. For the opinion of this court, reference demand being made in 21 on 28/7/21, a reference as an outcome of 4 rounds of litigations being made on 8/2/23, there is sufficient delay in undertaking the industrial adjudication exercise. This court, while dismissing the writ application as not finding no substantial ground, no ground to substantiate the claim herein. This court direct the industrial adjudication if already in receipt of industrial adjudicator, if already in receipt of the reference to proceed with the matter immediately.
That is going on, my lords.
Going on,
Yes, ma'am.
as stated by Sri Mishra, the reference is already undertaken by way of industrial adjudication in ID.
Sir, number ta mo pahe nahi, but it is
They already taken in the industrial adjudication in such event. The industrial adjudicator is directed to show lawful conclusion of such adjudication in the involvement of the parties involved within. Repression dismissed, no cost.
deeply obliged for giving a patient hearing, my lords.
No, this is industrial adjudication. Therefore, I am to give patient hearing definitely. Yeah, rather, and both of us.
Because
again,
that is my lord's favorite.
Mr. Mishra, I am again
My
revising,
lord's favorite subject.
rewinding my mind in industrial side after so much.
My lord's favorite subject, I know that.
This is a matter, my lord.
Yesterday we have passed an order interfering in the reference.
My lords.
Interfering in the reference.
No. My lords, this is my duty, my lords. My lord, I have
No,
my...
absolutely. But see, luckily the industrial adjudication already commenced.
My lords.
See, otherwise, in this process,
add ହେଇଯିବ ନା ଯଦି if at all your lords. Yes. That is the prayer also. That is
and
the prayer.
now, as we have observed, your rights are not precluded, not
No,
taken away even.
That way I am again grateful to your lordship.
So it has strengthened rather you.
Sir.
Okay. That is one of our prime duty. 5ଟା 6ଟା read ହେଲାଣି ଆଉ କେତେ read petition ଜଣେ ବୁଝିବ?
Sir.
Item 6.
Yes, my lord. This is a matter, my lord.
Right, yes, item 6.
Yes, sir. I want to petition, my lord, the poor workman. He seeks for a transfer of the matter from Labour Court Sambalpur to Labour Court Bhubaneswar, my lord.
Labour Court Sambalpur to
Labour Court Bhubaneswar, my lord.
Who is intending transfer? The workman?
Workman, my lord.
Why it was referred to Sambalpur then? What is the established institution involved?
Sambalpur, my lord, he was
Management
working there.
is-
He was working there.
He was there working there. Therefore, evidence purpose, it will be convenient if it is held there.
He is a Sikh, my lord.
Pardon?
He is, my lord, suffering from different ailments. That is Sikh, my lord. That's why he is now in his village because terminated.
Village. Where is the village?
Bhadrak, my lord.
Bhadrakରୁ ଭୁବନେଶ୍ୱର ଆସିପାରିବ, ଭଦ୍ରକରୁ ସମ୍ବଲପୁର କାହିଁ ନ ଯାଇପାରିବ? In any case, he is to move. କଣ ପାଇଁ? କେବଳ ତାର evidence ପାଇଁ. କେବଳ ତାର evidence ପାଇଁ.
Each day he could not appear, my lord.
We don't
Because now
find
they
it
have
so.
not filed the
We don't. ଶୁଣନ୍ତୁ,
Douglas.
the problem is management is a functional there. You may like to examine witnesses of management. You will definitely examine. Management may like also examine some witnesses.
Yes, my lord.
So it is better for convenience of both sides there.
Yes, my lord, the workman, terminated workman.
Oh, no, terminated, therefore, ତା ଗାଁ ପାଖରେ କୋର୍ଟ ଖୋଲିଦେବା କହୁନାହାନ୍ତି।
ନାଇଁ ନାଇଁ ଭୁବନେଶ୍ୱରରେ ହେଲେ
That cannot be a ground, sorry।
ଭୁବନେଶ୍ୱରରେ he was admitted in
କହିବେ
ଭୁବନେଶ୍ୱର
ଟାର୍ଗେଟ କରିଦବା, କହିବେ ଟାର୍ଗେଟ କରିଦବା।
ଟାର୍ଗେଟ କରିଦିଅ।
ଇଭିନ୍ ଦେଖନ୍ତୁ ଆଜିକାଲି ତ ଆଫିଡେଭିଟ୍ ଇନ୍ ଏଭିଡେନ୍ସ ବି ଦେଇ ଦଉଛନ୍ତି।
ଦେଇଛନ୍ତି different dates,
ତ ଖାଲି କ୍ରସ୍ ଏକ୍ସାମିନେସନ ପାଇଁ ଆପଣ ଗୋଟିଏ ଡେଟ୍ ଯିବା ଦରକାର।
each day, my lord, they are not filing and they are mentioning that he is absent. And they are not filing
No,
the
you can
double S.
see-
The only
Is it
opposite
not
part number one
represented
is
by
filed.
lawyers? It is not represented by lawyers.
No, my lord.
You can engage a lawyer.
No, ତାର ପଇସା ନାହିଁ ଆଜ୍ଞା।
ଆରେ ଆରେ,
Terminated lawyer, my
ଆପଣ
lord.
ସବୁ
ତ
ହଁ ଏରିୟର ସାଲାରୀ କେତେ ଏଭିଡେନ୍ସ ସବୁ ଗୋଟାଏ ଦିନ ଯିବ।
ହବ ଯେ
33C2 again ଏରିୟର means undisputed salary, ସେଥିରେ ଏଭିଡେନ୍ସ ବି ଦରକାର ନ ହେଇପାରେ। କାଉଣ୍ଟର vis-a-vis କାଉଣ୍ଟର, the claim vis-a-vis the counter, ଏଥିରେ ଏଭିଡେନ୍ସ ବି ଦରକାର ହବନି। 33C2 undisputed dues।
number of dates, they are not filing the
Sorry,
double S.
sorry, look
The man
at
lordship
this is
target.
a writ application involving the following request. Counsel advancing his submission brings to the notice of the court the followings: seeking transfer of the adjudication of 33C2 of ID Act proceeding by miscase number 5 of 22 runs as follows. 1. Petitioner being a terminated employee resides in the district of Bhadrak. 2. Petitioner being a terminated employee having no sufficient means to attend the industrial adjudication involved herein.
But, OP number 1 has filed the double S and OP number 2 to 5 are not filing the double S field date. my lord.
ସେମାନେ ଡବଲ ଏସ୍ କଣ ଫାଇଲ କରିବେ? ଆପଣଙ୍କର statement of claim ଟା ଫାଇଲ କରିଥିବେ।
I'm-
OP1 already filed.
Yes, but OP2 to 5 they are
OP1
not
is
filing.
management. ଏତେ ସମସ୍ତେ ଫାଇଲ କରିବା କଣ ଦରକାର?
But they are also not saying that they are adopting the
Where
counter
is
of
the
OP number 1.
claim petition?
This Annex 1, my lord.
Annex 1.
Yes, my lord.
ଆପଣ କାହିଁ ଏତେ ଲୋକଙ୍କୁ ପକ୍ଷ କରିଛନ୍ତି?
The dispute ଟା
ଦେଖନ୍ତୁ ଆପଣ ହିଁ ନିଜେ ଟ୍ରବୁଲ କରିଛନ୍ତି। You are claiming undisputed dues.
Yes, my lord.
It is only employer to be a party. ଆପଣ ବି ଇଣ୍ଡଷ୍ଟ୍ରିଆଲ
Yes,
ଚାମ୍ବର ରୁ
yes,
ଆସିଛନ୍ତି।
yes, my lord. But he has worked in
ସିନିୟରଙ୍କର
no, no,
ସିନିୟର
he has,
ପିଢି
but
ଧରିକିରି
he
ସବୁ
has
ଇଣ୍ଡଷ୍ଟ୍ରିଆଲ
worked, my
ଆଡଜୁଡିକେସନ।
lordship, he has worked before.
So, sorry, it is not necessary that each of these people will go and file a written statement. If they file, it is all right. If they don't file, we will target filing
Yes,
of the double S,
yes, sir.
and
My lordship, I
proceeding
target.
will be concluded within a certain period.
Yes, my lord.
Okay. Perusal of the grounds raised in the writ application. This court find undisputedly petitioner was an employee established in the district of Sundargarh,
Yes, my lord.
in the district of Sundargarh, coming within the jurisdiction of the labor court Sambalpur. You have filed the written statement of the OP number 1,
Yes, my lord. That's Annexure 2, my lord.
huh?
Annexure 2, my lord.
Answer 2, page,
Page
please.
18, my lord. Page 18.
Page 18.
Yes, my lord.
ସେ ପଢିଲେ କଣ ସେ ground ନେଇଛନ୍ତି?
That petitioner was not placed in any written order for working in agricultural farm or processing plant Borgaon, Sundargarh by the DDA Sundargarh. So there is no question of payment of any dues claimed by the petitioner Siddhas. The Siddhas was not served any work or duty in
ଆପଣ
the
ପଢିଥିଲେ ଏଇଟା before drafting ଏଇଟା ପଢିଥିଲେ?
Aye.
ପଢିଥିଲେ? You still realize that 33C2 will be maintainable? କାହିଁ unnecessary pursue କରୁଛନ୍ତି litigation? ଆପଣ you can raise industrial adjudication even. 10 ରେ ଯାଇ reference କରିବେ, ଆଗ establish କରିବେ, yes you are entitled to this. What the 33C2 says? It is computation of the admitted dues.
Yes.
So admitted dues means what? Either by way of an industrial adjudication or admissible entitlements undisputed by the employer.
Yes, ma'am.
Is it the case they are disputing now?
Disputing my annex page 15 annexure A is computed everything.
ହଁ ଦେଖନ୍ତୁ ଆପଣଙ୍କ ଇଚ୍ଛା, ଆପଣ ଘୁରିବା ପାଇଁ ଚାହୁଁଛନ୍ତି, ଆମେ କଣ କରିବୁ? Okay, perusal of the in the given situation, position of the employer, cause of action taking place. This court is of prima facie opinion that even assuming that the proceeding involved under section 33C2 of the IT Act, and in the event of any necessity of evidence, management evidence will all be available within the jurisdiction of Labour Court Sambalpur. Further, looking to the place of the petitioner, resident place of the petitioner presently, since residing in Sambalpur, this court find if a person, in Bhadrak, this court find if the petitioner is able to move from Bhadrak to Bhubaneswar, there is no reason as to creating any difficulty for his moving from Bhadrak to Sambalpur. It is in the above ground, and further also looking to the objection already on the 33C2 application by the management concerned, though this court not like to express any opinion at this stage, this court find there is no ground to entertain the writ application except observing for a poor workman involved therein. The 33C2 proceeding be attempted to be disposed of at the earliest, at least within a period of 3 months from the date of communication of order. Personal appearance of in the event the petitioner engages counsel or a representative, same may be permitted, and attendance of the petitioner may be for the purpose of evidence, if any, fixed to particular date, and his evidence may be concluded, if at all required, be concluded on the date fixed itself. Okay, with this observation, the petition stand disposed. ଦେଖନ୍ତୁ କିଛି ultimately ଇଏ ଖାଲି ପୋଷା ହେବା ଛଡା ଆଉ କିଛି ନାହିଁ।
For orders item 7.
Okay, neither ready nor brief. এটা sufficient ହେଇଯିବ। ମୀନାକ୍ଷୀ, okay, ଝିଅ ପିଲା ହେଲେ କଣ କରିବା? Postal tracking କାଇଁ?
Office ପଠଉଛି ତେଣୁ office ପଠଉଛି ସେ ପାଇଁ ଆମେ
Office ପଠେଇଥିଲା ଏଟା?
ଆଜ୍ଞା
ଏ postal tracking ସାଙ୍ଗରେ ଦଉ ନହେଲେ ଆଉ କେମିତି? Looking to the position of party in the respondent side before taking final decision on service aspect. This court likes to see the postal tracking report. This matter after 10 days, registry may attempt to obtain the postal tracking report on the service aspect on the respondent in the meantime and place it on record on the next date of posting. Which receive.
May I please, Your Lordship? Lordship, in the page 5, inadvertently, only the name of the petitioner has been wrongly mentioned as Birdville Walker Unions.
Pardon?
Lordship, in the page 5, the name of
Okay,
the
just
petitioner is
why it has come?
for modification, my lord.
Huh?
For modification of the order, my lord.
Modification of order.
Lordship,
This is your application.
yes, my lord.
Okay, what is the order passed?
Lordship, that's in page number
Modification of
5.
order dated 16/5.
Yes, my lord.
Let us see 16/5 order.
That's at page 5, my lord.
A memo has been filed by learned counsel for which is seeking withdrawal of the writ petition.
Yes, my only the name of the petitioner, my lord. Name of the petitioner in the order has been wrongly mentioned, Birdville, Worker Unions and others, my
Oh,
lord.
that is
That's-
need to be correct.
That's the only one thing, my
Okay,
lord.
all right, all right. Ita ki mahasaya, datta mahasaya. Could pailo ita tame. There is typographical error lekhi amaro responsibility set. This court therefore direct appropriate consideration in the cost title at petitioner side by deleting words inverted comma with a rakhiba and replacing the same by again inverted comma. In the process, the application stand allowed.
Item 9,
Item 9, my lord. Though I have filed already.
Change of
IA.
nomenclature.
Yes, my lord. I have already filed the IA.
Huh?
Already filed the IA for.
Okay, all right. There is also office reporting of changing the nomenclature of the matrimonial appeal to a GUAP. There is also filing of IA 243 of 23 to the said effect. This court, considering the office report as well as the request of the petitioner, permit the conversion of the matrimonial appeal to a GUAP. There may be suitable re-registration of the appeal, and there should also be further stamp reporting, and matter may be placed accordingly in the normal assignment.
Obliged, my lord.
item 10,
May I please, your lordship? The appellant is the wife, your lordship. Challenging the quantum of alimony.
ଟିକେ ରୁହନ୍ତୁ 9(2) defect ଟା କଣ?
Defect तो remove कर देती लिखा है
ହାଁ?
defect टा remove कर देती तो
9(2) page 2 to 8 of the petition not signed by advocate. Permit कर दो जाओ.
आगे आगे.
Counsel for the petitioner to bring his signature on the body of the petition, page 2 to 8 in the court itself. Like it kar deyi jibe.
My lord.
Okay, now who has come in appeal?
Wife has come in appeal
Against what order?
against the actual quantum of alimony has been not commensurate with the income of the husband, your lordship. He has
Okay,
stated,
only on quantum.
my lord,
It diverse also there.
diverse is there.
So you don't want to challenge diverse.
No, only quantum.
Okay. What was the material you had produced?
My lord, my kind see, it is his the own deposition. If your lordship will see the deposition, which starts as page 31. He was working as an Havildar.
Working as a Havildar.
Yes, your lordship, in ITBP.
And your position?
I am not, I am housewife. I was in house.
Only housewife.
And he,
Ajikali housewife kuhahabani pura?
homemaker.
How କହିବେନି?
Say, my lord, may kindly turn to page 33. He has himself stated.
I am an unemployed woman.
I am.
You can say that, but housewife how କହିବେନି? Can I say termination say nomenclature gala?
We have to practice for that. My lord, may kindly see page
You
33.
can at best say I am the home minister, looking after the affairs of the home.
My lord,
Yes, your affidavit, page 31.
my lord, deposition copy, in his deposition copy, your lordship have annexed page 33. My lord, may kindly see, he has admitted
Page 33.
3. Yes, your lordship. It started at page 31.
No, that is only cross-examination.
He has stated my gross salary
Okay,
is.
he has stated.
He has stated.
କେତେ ଟଙ୍କା କହିଛି?
Say 65,000 koichi. The court is saying that is 55,382 and direct the anomaly for only 6 lakhs, your lordship. And the girl, the
65 ହେଲେ 25% ହେଲେ ବି ଧରନ୍ତୁ 15,000.
my lord,
ଲକ୍ଷେ 80.
my lord,
10 ବର୍ଷ ହେଲେ ବି ଅଧିକା ହେଇଯାଉଛି.
My lord.
Okay, all right. There is also increase in the salary.
yes, your lordship.
So material available ପଠେଇଦବା. ଆପଣ ଏ ଟଙ୍କାଟା ସେ ଡିପୋଜିଟ୍ କଲେଣି ନା ନାହିଁ?
Na kisi, I have not taken any money,
ଶୁଣନ୍ତୁ ଗୋଟେ କାମ କରନ୍ତୁ. ଆମେ this is our normal experience.
my lord.
ହଜବେଣ୍ଡ ଯେତେବେଳେ ଡିକ୍ରି ଅଫ ଡାଇଭର୍ସ ପାଉଛି ସେ ଫଟାକିନା ସେ ଟଙ୍କାଟାକୁ ଡିପୋଜିଟ୍ କରିଦଉଛି.
My lord.
To show that he has complied that direction. ଆପଣ ଯଦି ସେ ଟଙ୍କା ନଉନାହାନ୍ତି ତାହେଲେ ସେ ଟଙ୍କାଟା ସସ୍ପେନ୍ସନ ଆକାଉଣ୍ଟରେ ରହୁଛି, ସରି କରେଣ୍ଟ ଆକାଉଣ୍ଟରେ. And the appeal is now, we don't know when this appeal will come for hearing.
My lord.
In the meantime, wife is also not taking that money, so you are losing everything. Ask her immediately to take out that money.
Oh, then
We did
protest that I have already.
It's only saying that
Ah,
without
without
prejudice you
prejudice.
take it.
Yes, yes.
Because after 16 years we have discovered, we have to inquire from the Lorded Trial Court, find out ourselves what has happened. None of the council also doesn't know.
We can't even burden the husband now. After 14, 15 years, we find the deceased very recently reporting us that money is lying in the current account. Then the 8 ଲକ୍ଷ ଟଙ୍କା 13 ବର୍ଷ 14 ବର୍ଷ ପରେ 9 ମସିହା ଡିପୋଜିଟ୍ 14 ବର୍ଷ 14 ବର୍ଷରେ 8 ଲକ୍ଷଟା 3 times ହେଇଯାଇଥାନ୍ତା. ସେ 24 ଲକ୍ଷ ହେଇଥିଲେ ଆମେ ଆଉ 8 ଲକ୍ଷ 6 ଲକ୍ଷ ଦିଅ ବୋଲି କହିଥାନ୍ତୁ, ସରିଥାନ୍ତା ଖେଳ.
My lord.
ବର୍ତ୍ତମାନ ଆମେ 8 ଲକ୍ଷ ଉପରକୁ ଗୋଟେ ପଇସା ତାକୁ ଶୀଘ୍ରରେ ଦେଇପାରିବୁନି କି ହଜବେଣ୍ଡକୁ ବି କହିପାରିବୁନି, ଆମ ଦୋଷ. We have to think seriously on that issue. State କୁ କହିବୁ କି ତାକୁ ଟଙ୍କା କିଛି ଦିଅ, କଣ କର. କୋର୍ଟ କୁ ବି ଆମେ ବର୍ଡନ, ଆମେ କୋର୍ଟରେ ଆକ୍ସନ ନବୁ କହିଲୁନି, ଆମେ ରିପୋର୍ଟ ମାଗିଲୁଣି, ତମେ କାହିଁକି ଏଟାକୁ ରଖିଲ ଏଥିରେ, ଆମକୁ କାହିଁ କହିଲନି this money is lying, what to do. ତେଣୁ ଆପଣ ତାକୁ କହିକିରି without prejudice my dispute on the enhancement
Yes, yes.
ଏଇଥିରେ ଅଛି, ଆମେ ଏଥିରେ observation କରିଦଉଛୁ. You may withdraw the amount without prejudice to his or right at the submission of learned counsel for the petitioner. In the course of submission, in the course of submission, Sri Dwivedi learned counsel confined the appeal only to the issue, only on the issue of enhancement in the permanent alimony. Thus, the appeal is confined to consider enhancement in the permanent alimony, if any. So far as diverse aspect is concerned, okay, this court finds. In the process of submission, Sri Dwivedi took us to the own admission of the husband submitted his deposition as DW1 to admitting gross salary at that point of time to be 65,000 per month. Being working as a constable, ITBP, RTC, Kerala, Karera in the state of MP. This court is satisfied with the grounds for enhancement. Accordingly, direct issuing notice on the question of admission, considering small issue involved herein. Yes, recusals has undertaken be filed by 3 working days. Notice be issued to the husband respondent herein, fixing short returnable date. Matter may be liberty granted to the counsel for the wife to approach the assigned bench for all the hearings. At the same time, this court, finding the appeal confined to quantum aspect, if involving a request for enhancement in the quantum of permanent alimony, there shall not be any prejudice to the wife appellant in withdrawing the amount already in grant by way of permanent alimony, which will be, however, subject to without prejudice to the rights and contentions of the appellant herein. He placed 1 month after the date 1 month. You find out there whether he has deposited or not.
Yes, I'll find out. My lord, this is registered post with ID or speed post, your lordship, notice?
Speed post
Either
is normal.
registered oblique speed post ଲେଖା ହଉଛି
ମାଗେ।
ଏ ଜାଗାରେ speed post ନାହିଁ ବୋଲି ସେ problem ଟା issue
Yes,
ଅଛି
yes.
ନହେଲେ ଆପଣ speed post
ଏବେ
ନେବେ
ବୋଧେ speed post ସବୁଠି ହେଇଗଲା।
ଆଉ ହାଇକୋର୍ଟ ର ରୁଲ ରେ ହେଇଯାଇଛି speed post
ଆଉ ଏଇଟା ITBP ଆପଣ ପଠେଇ ପାରିବେ, ଏଇ ଯେ ସେଣ୍ଟ୍ରାଲ ଗଭର୍ନମେଣ୍ଟ ଏମ୍ପ୍ଲୟି must be posted in a urban area.
My obliged.
My lord, item.
କେତେ ଦିନ ହେଲାଣି ଏଇଟା ହେଇକିରି? ଜଜମେଣ୍ଟ ହେଇ କେତେ ଦିନ ହେଲାଣି?
ଏଇଟା ଏବେ ଜଜମେଣ୍ଟ ହେଲା ଜୁନ
Must have deposited ନେଇଯାଇଛି ନା ଡାଇଭର୍ସ ଏଟା ଦେଇଦିଅ।
ଜୁନ 30th of June ଲେ।
June 2 ମାସ। But sometime intelligent lawyers advise to challenge quantum. And ସେଇଟା ବି appeal file କରିଛି admit ହେଇଯିବ।
Item 11.
ଦେଖନ୍ତୁ ସେ କାଳେ appeal file କରିଛି କି? On quantum aspect.
My item 11. As a year 2015 matter, last occasion, my lord and senior was not willing to settle the issue or to my lord about the alimony.
There is a fellow
Then I have filed an miscase for enhancement of my interim maintenance. Only 4,000 he is giving. Union central government employee, my lord.
This is all interim maintenance or permanent alimony.
No, interim, my lord. Permanent alimony. I wanted permanent alimony because throughout these years I wanted to reunion, and only on the obstinate attitude of the husband, the conciliation failed in High Court. So never I have demanded a single pie because I am throughout under impression that I will be there will be a reunion.
No
But
question
due
of
to-
any obstinate attitude. I have given a
Let
red
me-
chat, your
let me
lordship may
submit.
kindly see.
Just 1 minute.
Please.
Mr. Das, just
my
1 minute. Let her
petition.
complete.
Also,
Let her
I have right
complete.
to say.
Let your talk comes,
No,
My
Madam
lord.
Mahapatra.
my lord.
Madam Mahapatra, this is arising out of CP 117 of 2010.
One matter number 140 of 2015. 40 of 2015, my lord, is my application. And
Matter 140, we understand.
my lord,
This is
CP,
arising
my
out
lord,
of
CP,
CP.
117 of 2010 and 180 of 2011.
Yes, those are the two CP.
My
So
lord,
both are decided together.
my lord.
Yes.
One CP is 13, section 13, and
My
one
lord.
is 9.
No,
Dita CP कौन पे थला?
Gotepsi, my lord, for judicial separation because there was physical torture and all that thing for a
Right, that was by wife.
by.
Okay,
Then, my lord, one other is for divorce by the husband.
divorce.
Divorce.
So therefore, what is the ultimate outcome?
Outcome is, my lord, divorce is
Judicial
allowed.
separation is dismissed, divorce is allowed. Okay. Now, but there is no case for compensation at all.
No,
So how can we entertain an appeal on compensation aspect?
my lord, we have challenged that. I am challenged the divorce. And in that order, my lord, there is an order from this honorable court that 4,000 may be allowed, and they have filed a 107 of 2021, my lord, that
Therefore,
order.
the appeal is not entertainable, madam. Some court has passed order that doesn't bind us.
My lord, that is
Look to section 25.
my lord, that is on my lord, kindly see 212.
Aଜ୍ଞା, ଆପଣଙ୍କ appeal maintainable ନୁହଁ compensation ଉପରେ.
No, I am not on compensation.
So divorce you challenge.
Yes,
So you challenge divorce.
divorce, my
So
lord.
confine to that.
My
Mr.
lord.
Patra, since you have already filed an IA, narrating a difficulty that 4,000 was allowed. 4,000 was allowed in which petition?
My lord, 22/12/2021 order.
Who petition in this court?
One for, that is IA number 1070/2021.
But kindly see 25(1), because you have a right to get that.
My lord.
So, but you have to move that petition. You are
My-
not showing that petition.
My lord, that petition is IA number.
No, you
Not
can't
IA,
speak by
not
IA.
IA, not IA.
It
Man,
has to be
before-
adjudicated.
25(1), 25(2), even by adjudication by the High Court also, post adjudication also it will be there.
My lord.
Let it continue. You approach for compensation.
My lord, because.
And one more thing, Madam Mahapatra, you have to be careful in making submission.
My lord.
If you now advance your submission on permanent alimony or enhancement in the compensation, then you are foregoing your challenge to the divorce.
Because he is not
Both
willing, my lord.
both cannot go together.
My lord, because of conciliation report, he is not willing all along.
Then what do you say?
Then
You
he-
say that there is no question of reunion.
No, here from my side, my lord,
Then
he is
you are
not willing.
abandoning. Then let us go step by step.
My lord.
Jama दौड़िबे नहीं.
No, sorry.
You are fighting a litigation.
My
They are
lord.
more concerned than you.
My lord.
In that event, if you say enhancement in the interim maintenance,
My lord.
then you are abandoning your relief so far it relates to divorce. One. Number two, now for the provision at section 25,
My lord.
this is an adjudication at the threshold.
My lord.
So be satisfied, whatever interim order is passed here, let the proceeding be pending. You go and initiate a proceeding.
My lord, my submission is, because there is a chance of reunion, I have never demanded a single pie as an interim maintenance till 2021.
And that point is well taken.
My lord.
But you are saying that you are facing difficulty. For all that, you have to have a petition where it is to be adjudicated, and that is 24/25.
My lord.
So what has happened here? You have never moved 25(1).
Before the court below.
Exactly.
My lord,
Absolutely.
that petition, because
Absolutely.
wife is under impression
No, now
that
you find
Well,
what will be the best
and-
course to help your client.
till 2021 also we have never demanded, my lord. My case before your lordship is that.
Only we can request the other side if you can enhance to certain extent that 4,000.
Millards, I am.
Because you see, there is now what is happening? There is
If-
failure.
I
Appeal is
know
not
that,
maintained.
Millards,
No.
if your lordship will see my dead chair, my
No, we are
embarrassing
not
position.
entering into merit. It's only humanitarian consideration to that extent
Only
we can
I
tell
will
you.
take instructions from the
We'll
client.
leave that, we'll
I will
leave
take
that aspect
instructions
to
from the
her.
client.
She may go in appropriate proceeding.
You have
But
heard
let her be surviving.
I will
So
take,
we'll expect good sense will prevail.
no, I will not
You
say
will be
anything.
in a position
I
to.
will take instructions. I am not going into any other things. There
No,
are
but
many.
if Mr. Das, persuade your client. Well,
I will
that's
try to
our-
persuade him.
That's
I will
our
try to-
anxiety.
I will try to persuade
You,
him.
old lady. Old
I am-
lady.
I am also
So
old.
survey, no, you are, it is not lady versus you. It is lady versus.
In-law, but in the next month from of the marriage.
ହେଲା, ଠିକ ଅଛି।
ଆଉ କିଛି କହିବାର
ଦେଖନ୍ତୁ,
ନାହିଁ।
ଆପଣ
ତାପରେ
ଯଦି-
I will take instruction.
ଆପଣ ଯଦି କିଛି ପଇସା ବଢେଇ ଦେବେ,
I will talk to her.
ଆପଣ
I will talk
ପୁଣ୍ୟ
to her.
ଅର୍ଜନ କରିବେ।
I will take.
ସେ ପାପୀ ହେଇକି ଥାଆନ୍ତୁ ଆପଣଙ୍କ ଭାଷାରେ।
I will take instruction.
Next week. Yes,
Next week, Your
next Thursday,
My lord, that
keeping in view the peculiarity
date charge
involved
will be
herein,
there.
this court direct Mr. Das, S.T. Das, senior counsel to take
25 remove
instruction from his client on the aspect of enhancement in the interim maintenance. This could record the submission of Ms. Mahapatra that looking to the conduct of the parties in between, the revelations through the mediation report. The appellant is no more interested to pursue the litigation on the divorce aspect. Record कर दो अपना divorce टाको challenge करना है
नहीं फाइल करती डाइवोर्स चैलेंज कर बट इट इज नॉट वर्किंग आउट हम चैलेंज करची मैं क्या କିନ୍ତୁ ସେ କହୁଛନ୍ତି ଯେମିତିଆ କଥା ଆଜି
ଆପଣ multiple ନାଁରେ ଗୋଡ଼ ଦିଅନ୍ତି
ନାଇଁ ନାଇଁ ସେ my learned senior submission see
I am not saying anything, I am only on record.
but my learned senior submission is what my lord kindly mark that I am staying with somebody else.
Yes.
Sir.
These are all records, court has recorded that.
All legal solutions are not possible for emotional issues. She might be having emotional issue there, whatever. But आपण निजे भावंतु where she is heading. This will not end.
That in expertise they have got an order that she the divorce.
Will you get any benefit, ultimate outcome?
2003
Since you are already made up your mind to stay apart.
Yes, no, I have never made up my mind. My lord, I surrender because I want. My lord, I take all the blames because I wanted to be reunited. And he is only his allegation.
देखिए next week रे she the अधिकार
My lord, my lord.
I'll take instruction.
Don't
He is
place
filing
matters
objection
here.
to the minimum
Remedy
maintenance.
under
and
section
filing.
25. This next.
Item 12.
Your lordship.
ये संजय प्रधान को नाम कहीं इधर बाहर उची इधर है. Probably there is previous direction to take out name of Mr. Sanjay Pradhan. देखना. We remember sometime he directed to take out his name. There is subsequent appearance by Ms. Mahapatra. Find out whether अच्छी हमें already direction करथिलु. Or there is new appearance by Mrs. Mahapatra. कर दो. देखी दो किंतु before that find out probably there is order then you have to give reference to that. ये ऊपर रोनी confusion हो ना. को दया करी कुछ समझ देगी. Yes, item 12.
Your lordship, presiding officer labor court's order is under challenge. Presiding officer's labor court order is under challenge. Notices were issued. Opposite party number 2.
The order or award?
Order, your lordship.
Order.
Your lordship.
In a miscellaneous proceeding.
Your lordship, the proceeding emanates from actually the Supreme Court's order judgment actually on 13/8/1985, wherein a direction was issued by the Hon'Ble Apex Court to give the benefits of 200 workmen who were working prior to 1960 for construction of Hirakud Dam project.
Right. Then a miscase was initiated on the basis
your lordship,
of
your lordship. And thereafter,
Then who are you? You are the management.
Your Lordship, OHPC, Your Lordship.
How long these issues will go on?
Lordship, Supreme Court has
He
fixed
must
it.
have given a direction for payment.
Your Lordship,
What is the direction ultimately?
Your Lordship, ultimately it directed to get keep the benefits as
So
running
that,
page
therefore
20.
answer how long this issue will go on.
Your Lordship, the Honorable Apex Court has given a direction, a time schedule for that. On 28/9/1988, direction was given to the Labor Court to find out the employees who were working under.
Right.
And thereafter, no direction, no extension of time was given. So after a period of 20 years or 25 years, she has approached the Labor Court saying that I am one of the my father was one of the employee who was working prior to 1200.
So necessary exercise must have been done. You had appeared there or not?
No, Your Lordship. Sorry, Your Lordship.
You had appeared there or not?
Your Lordship, yes.
You have
We appeared.
protested.
Your Lordship.
So come to page 17. What was your case?
Your Lordship.
He came and filed the workman came and the beneficiary rather
Your Lordship.
came and filed a case saying that his father was a victim
Your Lordship.
in the process of eviction.
Your Lordship.
Now what was your case? See page para 3, page
Your Lordship.
17.
The opposite parties filed objection stating inter alia that Durga Seth was appointed as FITA grade 3 on 17/3/1961.
So undisputedly Durga Seth was the father.
Your Lordship.
Proceed further.
In the said post up to 31/10/1963 and was reappointed on 1/10/1963 and continued up to 16/12/1982 till his death. According to the opposite parties, Durgu Seth was appointed in the year 1961, that is after the dam project was handed over to the state government, and therefore he is not entitled to get any benefit of the order of Honorable Supreme Court. The petitioners filed several documents in support of his case, whereas opposite parties did not file any document.
Perusal of materials. Please read para 5.
Your Lordship, on perusal of the
Who
materials,
appears for workman here?
I find that duplicate service role of
Who appears for workman here?
notices were
been
issued
or
no.
not? Issue notice hardly on 24/1.
2023.
So for 6 years you did not press the writ application. Now after 6 years you are pressing the writ application. In January 23 notice is directed to be issued. Now what happened to notice? Unless the beneficiary involves, what can we do? Yes, admission stay notice issued to OP number 2 by speed post with AD fixing 10/2/23 for appearance. AD not back from OP2, hence tracking report is at flag B. Item received. The loco କୋଉ ମସିହାରେ ଏଇଟା ହେଇଥିଲା 88 ରେ ନାଇଁ ସିଏ ତ 61 ରେ ଇସ୍ୟୁ ଏ ପ୍ରୋସିଡିଂ ଇନିସିଏଟ ହେଲା 88 ରେ ଏ କନେଇ ସେଟ ର ବୟସ କେତେ ସେ ନେତା ବାପା ରିଟାୟାର କରିଛି ଏଟା ପୁଅ ଆସିକି ଜଏନ୍ କରିଛି एटी एट रु आज केते वर्ष हला 12 23
35 years
35 वर्ष हला
35 years
सो आपण एज टा को भी देलेनी योर पिटिशन इज डिफेक्टिव वी डिसमिस
I'll file an amendment application also.
Your petition remain defective.
I'll file an amendment application also.
And in the meantime, you bring out a paper publication in the locality. ସେ କଣ ଅବସ୍ଥାରେ ଥିବ ସେ ଗୋଟେ ଏଇ ତ ଦୁର୍ଦିନଗ୍ରସ୍ତ ଏମାନେ ସବୁ ଏଇ ଯୋଉ ହୀରାକୁଦର ପ୍ରୋଜେକ୍ଟରେ
So,
Helped on the ousties only. Where is the Supreme Court order?
I've quoted it, Your Lordship. I'll produce the order next on the next article.
No, kindly check what, if he is treated as a CPWD employee, what benefit he will get? Because the order is silent.
Your Lordship.
Order,
So,
the order
you should have
unworkable.
also mentioned you should have mentioned on retirement, these benefits he has got, this salary he has got. So how it will be beneficial to the ultimately the person? Dugru Seth joined in 63, worked till 81, retired.
Your
He
Lordship.
received his salary and everything. Suppose you treat him as a CPWD employee, so what benefit he will get?
Lordship. I'll file an affidavit to that, Your Lordship.
They said she is not entitled on account of that fellow. Ye taku kahidele. So therefore it is necessary to see what is the bone of direction in the Supreme Court order. Se order ta apan pakhre copy न रखी केम सब file कर दउछन read petition. This proceeding emanates from a Supreme Court direction or
Lordship, it
not?
emanates from the process.
Should you not be careful to keep that, see that order in quote kar dele, quote kar dele. Quotation definitely from a order, you must be keeping that copy. देखो तो अपन फाइल लेती बना कोर्ट का लेके मिलते अपन.
Nice. I don't have it, Your Lordship.
So insufficiency of material dismiss कर दो. जान दो
Lordship, I'll produce it on the next date through by filing an affidavit, the Supreme Court's order, Honorable Supreme Court's order.
This is no way assisting the court. फाइल ହେଇଛି କେବେ 17 ମସିହାରେ. Half-hearted filing without collection of all relevant materials. Your first contention should be for the Supreme Court adjudication, issue remaining such, whether this benefit comes under that issue, this is an employment related benefit. Supreme Court was taking विस्थापित लोकों को विषय से विचार करथले. ता देरे एम्प्लॉयमेंट इश्यू आसला केमती सुप्रीम कोर्ट रे आपन को वकील भगवान जानती केमती कॉन्टेस्ट करथले जे ठीक अछि एक केस रे कॉन्टेस्ट हेनी. She is taking an advantage of some order. अच्छा आपन को जो फाइल कले सेठी ऑब्जेक्शन पढुतले पैराग्राफ 3. You are also not careful enough to draw the attention of the authority. Sir, Supreme Court is dealing with such and such subject. This is not a subject to be taken care of under that purview.
I have actually filed that in the objection. I have taken that amendment. That is at Annexure 3, Your Lordship.
No, without seeing that Supreme Court judgment.
Your Lordship, I'll file that.
Applicability and what is the contours of that judgment. Because now it has become kind of I mean, again and again since continuing.
Business में गेलानी. It is business with some leaders there. पके जो application हमका किस तरह मिल जो.
I'll file an application. I will file an affidavit along with the Honorable Supreme Court's order.
That the Supreme Court was dealing with such and such subject, and therefore this issue doesn't come under that subject. Full election.
Lordship.
Page 25, 26.
Your Lordship, 26 it starts from 26, Your Lordship. The Honorable Supreme Court in Civil Appeal number 348 of 74, 349 of 74, between workmen of Hirakud Dam project and management of superintending engineer by order dated 13/8/1985 has decided that the workmen working in work charges of the Hirakud Dam project from before 1/4 since it is revealed from the records, the petitioner was appointed in the year 1961. That is after the project was handed over to the state
But
government.
therefore, you have objected on the footing that he was not an employee prior to 60.
Your Lordship.
And he only came after the handing over of the project to the
Your Lordship.
establishment. Therefore, is not entitled. So maybe wrong order. We'll examine. Let the service aspect is concluded. I'm a service aspect to put the direction. It is asunita se. कौन करिया पेपर पब्लिकेशन तो मैं एक्सपर्ट हियरिंग कर दो आसुनी से तो सर्विसिंग यानी कोई सी जो ट्रैकिंग रिपोर्ट कोई सी get today's order. You will get today's order. Your claim you have as discussed in para in your objection.
Your Lordship.
Yes, page 26.
Page 26, 27.
So this has not been taken into say appears to be an employee prior to. (1960) 61, not an employee.
Your Lordship.
1960. So Supreme Court decision doesn't apply.
Your Lordship. Further, in the next paragraph, Your Lordship, we have stated that we have averred that that this period has already
Would you find anything that how the labor code proceeded? Was any document produced regarding his employment in favor of the employer? You are a co-officer of the court.
Your Lordship.
So this question should not perhaps you say, but since the other party is not appearing, we are asking you this question.
Your Lordship.
The petition doesn't disclose.
The application to be disclosed kon che kebolo kohuchi mo bapa 57 re blacksmith thile during December 57 in the project heitla appointed thile. Kintu apon to anichandi material, therefore the adjudication was necessary in horse, not in by way of this miscase. Sethipenga se kon ko management please.
Running page.
All right, the repetition will be allowed. In the setting aside of the impugned order. What a sort of slip record leki logay down. I'm daki dekhe. How uthi jua 12:30 la. Kali ki asu.
Shubhankar Rath.
Item number last matter.
कौन करिए आउ मैटर
से वर्कमैन तक कहितले जॉइन करिया पे वर्कमैन को कहितले जॉइन करिया पे
कोड है जो 14
yes only 1 minute because
13 is appeal involving what?
See, my application under section 13 is rejected by the lower court.
Under section
13 of the Hindu Marriage Act.
Rejected.
Yes, Lordship.
Husband application.
Yes, Lordship.
Row.
Lordship, in last occasion, I prayed for a mediation, Lordship.
Mediation कौन होती रहो? Okay, ही परिवो.
Other side can't be.
There is possibility of reunion.
No.
Peaceful separation na कौन चाहूँ?
Peaceful separation.
Another date. So,
आज appear करचंदी.
आया.
ठीक है, माइक्रोफोन ने कहले ठीक है.
Today I am appearing. Opposite party.
अपना mediation कौन in the light of in the wake of Getting divorce on permanent alimony
Yes, Lordship.
or reunion.
Seeking permanent alimony.
No, Hyperion. There can't be a conciliation in the approval of the divorce.
Because you see that you have lost in the lower court. Unless they agree, how we will direct that you go and get separation.
And appearance memo and record kardeva matter roibo hearing hobo.
देखो से जदि परे ताकर परिवर्तन है से कहिबे ताले हबो. Because you are she is the opposite party and you have lost in the lower court.
You just intimate your client. This is the intention of the party. Doesn't want to take you, but wants to pay. ହେଲା ସେଥିରେ ସେ ଯଦି ରାଜି ହେବେ ଯେ ହଁ ଆଜ୍ଞା ପେମେଣ୍ଟ କରନ୍ତୁ ତାହେଲେ କେତେ ଟଙ୍କା ଆପଣଙ୍କୁ ଦବ କଣ ହବ appearance on behalf of sole respondent by ଯେ ଆଗରୁ ଏ ଅନୁରାଗ ପତି ଆପଣଙ୍କୁ ପାୱାର ଦେଲେ
ଆଜ୍ଞା ପେନସନ ଦେଇଛି
okay with the approval of the earlier councils ହେଲା there is fresh appearance by ଓକିଲଙ୍କ ନାଁ ଭବାନୀ ଶଙ୍କର ଦାସ and his associates with the approval of the previous councils. Fresh Vokalatma file be kept on record. So name of the previous councils on record be deleted, and the next listing should show the names of the councils freshly appointed. Matter release egala from Joda. এটা কোন কৌতলে মিস্টার ত্রিপাঠী?
Can we change the last order? You lordship directed. Last order, madam.
My
No,
lord,
but I have,
my lord, may I please your lordship? In this case, your lordship kindly have a glance of your earlier order.
No, what
yes.
since there is less
Yes.
time left today or almost no time.
Issued an engagement order also.
Engagement order has been issued.
Issued, my lord. You compliance your lordship order as well as the order of the.
because your lordship's order
My-
was there, I went there, but he refused to accept, saying that unless.
No, that order has already been issued. Order has already been
ନାଇଁ
issued.
ଏଇଟା ଆପଣ ରି-ଏଙ୍ଗେଜମେଣ୍ଟ ଦେଲେ
Reinstatement.
ରିଷ୍ଟେଟମେଣ୍ଟ ଅର୍ଡର ଦେଲେ ତ
Yes, my lord.
ଦିଅନ୍ତୁ ମେମୋ ସହିତ ଏଠି ଦଉନାହାନ୍ତି
ଟିକେ ଦେଖେଇ ଦିଅନ୍ତୁ
ତାହେଲେ ଆୱାରଟା କମ୍ପ୍ଲାଏ ହେଇଗଲା
apply ହେଇଗଲା.
ଆୱାରଟା କମ୍ପ୍ଲାଏ ହେଇଗଲା
No, they have made it matter subject to outcome of this. Subject to,
this will be now closed.
no, because the my lord, the order was different. The order, my lord, the 33C2 application was allowed.
Other day we said you are in lot of confusions.
Well, I am not in confusion. I will clarify, my lord. I am not in confusion. They have filed, my lord, writ application.
Oh, you still say you are not in confusion?
No, my lord. I'll clarify, my lord. Because a mistake was committed, I should not say anything, my lord, about that.
Now that the order of reinstatement is issued,
Yes.
your 33C2 will be entertainable.
No, they have made, my
No,
lord, because the,
please answer.
my lord.
Now that a fresh reinstatement order is issued in terms of the award, whether 33C2 will be allowed to continue?
My lord, they have, if you also look at the order, they have not passed by in terms of the award.
You don't understand.
My lord, I think, my lord, there is a communication gap. The award is.
সেটা meeting হলো বলি। Now on the basis of this, we can specify.
What is the instruction regarding the arrears and all that?
My lord, back wages, 25% back wages with reinstatement. That was the order passed by this Hon'Ble High Court as well as the order passed by the Industrial Tribunal. That was complied. Only 15,000 something is.
That will create a positive vibe.
Yes.
My lord,
Then all proceedings will be closed.
Yes.
my lord, can you see that order?
You bring it by way of affidavit.
Yes, my lord.
Okay, we'll see it next week. Then it has been brought to the notice of the court that following the direction of this court, dated 10/8/23, there has been recalling of the earlier order. And there has been, in the process, there has been issuing of a fresh office order dated 22/8/23. Claimed to be in strict compliance of the orders passed in the read petition as well as the industrial adjudication involved herein, by way of reinstatement of the workmen in service as casual laborer in the office of Zonal Manager Bhubaneswar. Well, this court direct the management to bring an affidavit on the development in the above regard, as well as also in the involvement of clarification on the back wages part
Yes.
involved there.
Because they have indicated, this second paragraph they have indicated.
Asu tapare ame consider.
Petitioner may be directed to join.
By tomorrow, join.
हाँ देखियो हेलानी तो एतिकी तो हेलानी
ତାପରେ ସାର୍ ଭୁବନେଶ୍ୱରରେ ରହିବେ ବୋଲି କହିଲେ
next Thursday.
List, press addition item 1.
Limited prior mutation case is pending. Number is not there. Mutation case is pending. Minor.
Number is not there.
Minor.
Then how it will be established that such a case is pending?
OP2 pending. Minor. Yes,
Where is your averment that mutation case is pending? Where is your averment at least?
Minor.
9. So, not pressed.
Item number 2.
2 is it same?
No, sir. Demarcation case 54/2021 is pending. Okay.
Where do you find that?
Case number 54/21, my lord.
Where do you find that?
Page 18, my lord.
Page
18.
18.
Notice, my lord. Due to pendency of civil suit, this demarcation case was not proceeded. Now civil suit is dismissed, my lord.
Yes, here it is there, Allah.
OP2,
So
my lord.
page 19, na?
My lord,
18.
my lord,
Page 18. Page 19 also,
my lord,
there is already a notice.
my lord. But due to pendency of civil suit, the demarcation case was not proceeded. Now the civil suit is dismissed, my lord.
There is,
And now dismissed, my lord.
now it is dismissed.
My lord.
All right. Through page 19, it has been established that not only a demarcation case is already instituted, but there has been also issuing of notice involving demarcation case number 54 of 21. Considering the case is pending since 2021, the same is directed to be disposed of by the Tahsildar Vasnagar OP number so and so, at least within a period of 2.5 months, but I was providing opportunity to the parties likely to be affected.
Item 3.
May I please, your lordship? My lord, what plot was allotted to the petitioner under discretionary quota? The authority did not consider to execute the lease deed. The petitioner was before this honorable court and as per direction
So
of the
Mahapatra, is it covered by any judgment?
Well, sir, in fact, it's not covered because my lord's direction is that in Navkishore Naik case, my learned friend, my lord's enclosed is page 38. Single discretionary quota. But fact remains in this case, the point.
only
No, but to be taken up as last admission. Because counter is there, I am to deal with this. Yes, next.
Item 4.
Pass over it.
May I please, Anna?
Yes.
My lord, in this case of the petitioner, my lord, petitioner purchased the case land and above 55 years.
Just 1 minute. Is it Lord Donna Temple matter?
My lord.
So I am not doing.
My lord, very innocuous prayer, my lord. Annexure
limited
3.
prayer ହେଲେ ମୁଁ ନଉନି ମୁଁ ଯେହେତୁ ଶୁଣୁ ନାହିଁ ତାଙ୍କ ମ୍ୟାଟର limited prayer ହେଲେ ବି ମୁଁ direction ଦେବିନି. This court is not hearing Jana Temple matter.
My lord, on that may please.
Rest may obtain permission of Honorable Chief Justice for placing the matter before any other available bench. Yes.
Item 5.
My lordship, I beg your leave to appear virtually. For
Yes.
next 4 months, I'll not be able to travel, so that's why I'm not present physically. Lord, the case here is that I am challenging the demarcation which has been carried out by the revenue inspector and Tahsildar in my.
Yes, this matter was heard on 17/7. Yes. There is some direction there.
Present that day. I was not present,
Lordship.
my lordship.
We filed our counter also, your lordship.
Also 2,
But
3
the
and 4.
The counter, my lordship, the counter also clearly states that this demarcation has been carried out in my absence. And there was only one date on which they attempted to serve notice, that is on 30th. And then on 31st, they have carried out the demarcation. And my lordship, the way
That is the only ground. The exercise is taken behind your back.
my lordship, not just that, I am also aggrieved because the partition of my father's property has the partition.
Okay, then matter will be hard. Any private party there?
My lord,
You are there.
3 and
So
4.
it
3
will
and
be
4
hard.
is the sister and mother of the
It will be
petitioner.
hard. You bring your counter.
I have filed the counter, my lord.
Okay.
My lord, I have stated the demarcation.
Please, no final outcome now. Yes, sir. The pleadings completed.
Your lordship had already heard the matter
Heard
day
the matter.
before yesterday.
Oh, yes, right.
If, my lord, the grievance of the petitioner is
Matter is
that,
final hearing, Allah delisted, yes. Next.
Item 6.
What is getting to the? Yes, I am granting liberty, Mr. Mishra. I am granting liberty in the case of urgency to approach the other assignment, next assignment for early hearing.
my lord, if one
No
suggestion,
hearing now, Mr. Mishra, you know my mind, state of mind now.
your lordship may.
Therefore, I don't enter into.
I
vast
bowed down.
controversies.
I bowed down. If the grievance of the petitioner is that the demarcation was without interruption, though notice was affixed, your lordship may fix up a date. The petitioner
Date
to
is contesting.
Lordship may remand the matter.
Maybe-
remand the matter.
Remand the
I have
matter.
a
I
counter.
may be permitted to file a rejoinder, my lordship. if my
But
lordship.
police protection may be there because he is assaulting the mother.
No protection can be.
That is-
Suppose
Suppose.
measurement time protection is necessary.
Yes.
Tahsildar will do well in ensuring the police presence.
Your lordship may observe that the petitioner is assaulting the
okay.
3 and 4. She is creating distance. Already it has been
But
demarcated,
FIR I
made
have
and down.
already registered. My lordship, my FIR is there in annexure
ये
3.
जोटा कहउछन जदी आउथरे मेजरमेंट डिमार्केशन ताले आउथरे हो बट सब्जेक्ट टू पुलिस प्रेजेंस कान ये मारुचंती माकू आ मते
Subject to my appeal is over.
नहीं सी आगे डिमार्केशन सरी जाईची तांको बाउंड्री अलगा आम बाउंड्री अलगा
No, the police protection टा हमें it is straightway direction दो ना. If the Tahsildar find inconvenient, one of the parties
Yes.
obstructing,
yes
then he arranges. That is
Your
passed
lordship-
with the Tahsildar.
your lordship may observe that aspect and your lordship my specific allegation she is assaulting the mother and old mother I am the mother से पूरा मो जागा को नेला ताकू 36 dismil already given आमर रहिला
Kindly hear me, my lord. My FIR is
Okay,
still
already done
there.
at that end of the matter. Yes, had the submission of respective commissions. Requisition involved following prayer. Confining her submission, learned counsel appearing for the petitioner attempted to demonstrate that the demarcation proceeding undertaken here is an outcome of expertise attempt and has been passed and has been decided in absence of the petitioner. In the course of submission, there is no serious dispute on the allegation of the petitioner, except the dispute raised herein by Shri Lalit Mishra and counsel appearing for the private opposite party, raising
3 and 4
to the effect that there has been attempt of assault by the petitioner whenever attempt for demarcation proceeding is undertaken. This court doesn't want to enter into such controversy at this stage. Finding there is no controversy in the expected disposal of the demarcation proceeding, the order in the demarcation proceeding stands terminated in case number here. Demarcation case 321 of 23 stands terminated. Matter is remitted back to the additional Tahsildar OP number.
OP number मिला
Additional Tahsildar OP number 2.
OP number 2.
OP number 2
OP number 2. For undertaking fresh exercise of demarcation in the involvement of both the both sides to facilitate early demarcation
And-
involving the demarcation proceeding, this court direct both the parties to appear with the order of this court before the opposite party number 2 on 30th of August to take the date of demarcation.
My lord, if I may submit one point, my lord, kindly allow me to submit one point. My lord, my appeal is still pending. If I can show a
No, no.
copy of the
That
appeal
is
with
not the subject matter.
consider also, then the
Sorry.
demarcation
That
may
is-
wait.
Sorry, let's see, you
Appeal.
place your case there, you place.
well
your
it is
case
not a
there.
maintainable
That
writ
may be
petition not
noted.
maintainable
My lord, kindly
however
that
she is
may be
asking
noted
Yes,
that
let
my,
her.
if my appeal
However, keeping in view the serious allegation made by counsel for opposite party number 3 and 4, it is left open to the opposite party number 2 take a decision as to
annexure D by 3
if
I
on
have-
the date of demarcation, if on the date of demarcation there is necessity of police assistance and proceed accordingly. The demarcation exercise should be completed within a period of 3 weeks.
and Miller annexure D by 3 already partition mutual consent that may be taken into
Oh, why are you submitting that? I am not taking a decision here.
Item 6.
okay.
But in this case, Lord, also last time directed state council
Yes,
to take
item
instruction.
6.
As per annexure 1, Lord.
I have already filed a counter affidavit.
Counter file kurchanti.
As per annexure 1, Miller.
File upon copy of counter file.
So today just I have received the copy, Lord.
So you will argue?
Let-
You will argue or go through the counter?
Yes, sir, Lordship call this one on Monday. I will look this matter. What is it? With the work, no.
Yes,
Monday,
there has
Lordship,
been
call this.
filing of counter by OP number 3 and 4. The service of copy on the counsel for petitioner. It no. Courtmaster, this is Lalitendu Mishra in the other case. A case re counter kahin. Kahin. By OP number 2. Hala. On service of copy, counsel for the petitioner wants to go through the same. Place the matter 10 days after.
But the interim order is there, Lordship. Interim order is there.
Interim order to continue.
Item 7.
May I pray, Lordship, fix it, dates.
Yes, item 7.
My lord, in this case, my lord, petitioner challenged the order of the opposite party number 3, seizing by the unit of the petitioner nursing home illegally in contravention to the clinical establishment and registration and regulation act 2010, my lord. On under Annexure 6, my lord, at page 37, a so-called notice was issued on 6/7/2023 to produce all these documents at page 37, my lord.
Page
37, my lord. Deputy Commissioner Enforcement, Cuttack Municipal Corporation, my lord. And this is a running unit of the nursing home, my lord.
Thereafter, what?
Thereafter, my lord, immediately on the
But it is
within
seized-
24 hours, he is.
It is seized on 11/7.
Yes, my lord. On
But
the
this so-called is 6/7.
so-called notice is 6/7, and I complied all these documents and funded before the opposite party note 3 on 7, my lord, which is
then-
under Annexure 7.
Then
Thereafter, without giving any reason, seized on 17/3, sorry, my lord, seized on under Annexure 1, my lord, no notice and no reply, no reason under Annexure 1, 11/7/2023 seized, my lord. It is a nursing home cum residential house.
Okay, then take notice.
Yes, my lord. I will take notice by registered post, by speed post, my lord.
Speed post, yes, all right.
And also, my lord, I have a miss case because now they are trying to seize my residential house also. Under Annexure 3, my lord, it is allotted, it is approved for first floor is for a clinic and second floor is for residential house, my lord, which is at Annexure.
Under Annexure 1, what has been only?
Only I have taken over the key. Yes, my lord. No other order, my lord. And also, my lord, under Annexures.
What is the allegation?
Only some documents to be furnished. Under Annexure 7, I furnished all the documents. That is under Annexure 7, my lord. On the very next day, I submitted all the documents, my lord. And they wanted building plan, current trade license, all the documents I submitted, my lord. Current year holding tax, parking area provisions details, and NOC. All these documents I have annexed under Annexure 7, my lord. Without considering those documents.
Corporation, anybody appears.
And also, as per rule,
who has seized?
The opposite party number 3, my lord. He has no power to enter into the clinic because, as per the.
It is exercised under what provision of law?
They have not mentioned any. They have only given so-called notice to produce all these documents. I produced all the documents, my lord. But
it's a clinical institution.
Yes, my lord.
All right, it should notice on the question of admission, fixing soft returnable date. The requisites by way of speed post AD as undertaken within 3 working days. Matter be listed immediately after the expiry of the appearance of opposite parties, contesting opposite parties herein. You came to High Court earlier also?
That is in a separate aspect, my lord, because regarding the land allotment, there is a partition under OLR Act.
That's a dispute against the.
No. Against municipality, no dispute. That is the interest dispute between the petitioner and other co-sharers.
As above, one said. In the meantime, there may not be any further coercive action against the petitioner. Without leave of the court.
Item 8.
May I please close? The impugn order is annexed, is at Annexure 7, page 27, your lordships. And my humble submission is, your lordships, in view of the decisions held in
Challenge
Sharat
Annexure
Chandra
7.
Annexure 7, your lords. Page
That's the
27.
order 15B.
15B.
Upon it, 15B order.
My humble submission that he should have
So
considered.
who are you? Are you a party to such proceeding?
No, your lordship. I am the legal heir. The petition was filed making
Legal
date.
heir of whom?
Legal heir of your lordships. Kindly see, the petitioner has made parties Chintamani Hota and Tiluchan Hota. I am the legal heir of the Tiluchan Hota, your lordships. And both, I am the legal heir of the, and
No, no.
making dead parties.
Sorry, 15B proceeding Ganga Rohidas
Again.
and how ki achi chite?
ତଳେ ଅଛି ଆଜ୍ଞା ଦେଖନ୍ତୁ versus state through ତହସିଲଦାର ଆଉ ଗୋଟେ ଅଛି ଚିନ୍ତାମଣି ହୋତା and ତ୍ରିଲୋଚନ ହୋତା page 23
କୋଉଠି ପାଉଛନ୍ତି vote?
page 23 your lordship annexure 6
page 23
petition right annexure 6
yes, you are legal heir of whom?
I am the legal heir of the both here से भाई दी जण चिंतामणि होता and त्रिलोचन होता.
So petitioner केते केते
हमें आगे पार्टी करा ही नहीं से डेड पर्सन को पार्टी करी केस करछि हमको लीगल हेयर को पार्टी करा ही नहीं
dead person ro legal heir
आगे.
So dead person is made as which petitioner or which opposite party? ସେଥିରେ dead person ଟା party ହେଇଛି କହୁଛନ୍ତି ପରା.
आज्ञा एटा परा चिंतामणि होता and त्रिलोचन होता both the sons होता died issueless hence they have not made party in this case died issueless कर देई जंदी.
ଆପଣ ଚିନ୍ତାମଣି ର ପିଲେ?
आज्ञा.
All right. There is serious allegation in challenge to the order at Annexure 7 passed under the provisions of Section 15G of the OSS Act. Particularly, taking this court to the allegation particularly involved Chintamani Hota, Tilochon Hota is surviving.
आज्ञा ना ना
से भी मर जाइए.
से भी dead. त्रिलोचन होता made a will in favor of the petitioner and I am the legal heir of the
Chintamani. तो एबे कौन consider करा होजी?
आज्ञा.
Chintamani and Tilochon both have died.
आज्ञा.
Okay. Taking this court to the, at this stage, taking this court to the cause title in opposite party side, involving Chintamani Hota, Tilochon Hota, being opposite parties, it is alleged both such parties are dead and there has been wrong indication, both of them having issueless. This petition is brought at the instance of the legal heirs of Chintamani Hota. This court find the case required to be examined. There is a case for examination. Accordingly, direct issuing notice of refugees as undertaken by day after tomorrow or by Monday. This case से notice कर दो status को in respect of the disputed property to be maintained as on date to be maintained. Next.
Item 9.
अच्छा this case अच्छी ना नहीं देखिला. Yes, Mr. Counsel. There is no miscase here. Sorry, काटी दे, खाली notice कर. All right, you only take notice. Next.
Here, my lord, this
Yes, Mahanti, Mr. Mahanti.
petitioner here challenges the inaction of the.
Please be on mic.
Yes. The inaction of the opposite part number 4 specifically, in not deciding its own decision, not carrying out its own decision under Annexure 8, kindly have a glance. A retaining wall or a protective wall was decided to be constructed in front of the property of the present petitioner. That is not being carried out. It can be well understood. I have annexed a sketch map. The facts can be clear.
So your intention in working out the Annexure 8?
Yes, that is, they decided it to construct a wall so that a drain can be constructed to protect the property of the present petitioner, because a new bridge was constructed through which there is a map. Kindly have a glance at Annexure 14.
So let us give direction for taking decision on Annexure 1, keeping in view the development in Annexure 8.
Annexure 8.
That's all.
Yes, please.
Instead of keeping this matter pending,
No,
it is
I don't-
better, let us.
Direction.
Read petition involve the following prayer. Taking this court to the development through Annexure 8, it is asked. Considering the grievance of the petitioner herein, there is already decision by competent authority to bring a toe wall, TOE dash wall along the periphery of his private plot, so that the petitioner's land is not affected by rainwater. Okay. Taking this court to Annexure 9,
Annexure 8.
counsel for the petitioner alleges in spite of representation on this regard pending before the opposite party number 4. There
4
is
is-
no development. And in the meantime, nearly 3 months have passed. Considering serious allegation as there is already decision of competent authority to bring a toe wall along with the periphery of the private plot of the petitioner, this court in disposal of the writ petition, direct opposite party number 4 to work out the direction by Annexure 8 by completing the construction aspect at least within a period of 1 month from the date of communication of the order.
Yes.
Yes, how say consider karibe, puni reject kar debe, se puni दौड़ुथिबे.
ठीक है.
Item 10.
Free copy of order be handed over to State Council.
My lord, not press. And I
Yes.
request to my lord, if I file a memo before the opposite party.
Only admission.
My lord.
Okay, fresh admission. Right.
Item 11.
Yes, is it covered?
No.
How say सब तेरे cover दे दूचुंदी आपण no कौचुंदी.
Kindly see the order dated 1/8/2023.
Yes, order date 1/8, please read.
No, directed to file a counter affidavit.
So you have filed or not?
No, we have to file.
आप कितने दिन नेबे?
Already other cases, we have already filed a counter affidavit.
Similar cases are pending.
Yes.
Here, my lord, the
State Council wants to bring counter affidavit.
May I submit, my lord?
And let the counter affidavit be filed within 2 weeks. It is made clear failure of bringing the counter affidavit within 2 weeks, the matter will be proceeded on the basis of pleading and documents available therein. Place the matter 2 weeks after the date taken. Yes.
Item 12.
May I please, your lord?
Just 1 minute, just 1 minute. Yes.
My lord, the grievance of the petitioner is to for a direction to the opposite party to complete the construction of a bypass.
Annexure 3 is pending.
My lord, before the collector, my lord.
Here, some of the petitioners.
Yes, my lord.
बंद अछि कि आपन माइक टा?
My lord,
ताका माइक बंद अछि बोधे.
No. Some of the petitioners have not signatory in the representation Annexure 3.
ହେଲା कोन होला रिप्रेजेंटेशन तो डिसाइड करिवे जी सिग्नेचर करछन डिसाइड करिवे कोन रे.
My lord,
This will give way in bringing a
my
writ
lord,
appeal.
executive.
Yesterday there is another development for the information of bar. The last Chief Justice has remitted a matter. Single bench passed order for non-submission of CCR of a person, promotion could not be considered for 4 years. So there is a innocuous direction, place the CCR within 4 months so that his case can be considered in next DPC. And you have a super brain
appeal committee in your Advocate General office, they have preferred a writ appeal. And writ appeal, the gentleman remanded the matter saying state will bring a counter. And there was time target for bringing counter. Unfortunately, no counter was even placed till the matter is posted before the single bench again. This is all going on. Right.
My lord, may I submit, my lord?
So, are you proposing to consider annexure 3?
No.
Huh?
My lord,
Dispose kariba?
yes, yes.
Na counter aanibe kai bhoy lagilani na single bench.
Engineer R&D division issued a notice to hold a police sabha under annexure 4, my lord.
Yes, so they will take that into account.
Yes, my lord. Pursuant to the police sabha, annexure
Right.
and resolution was submitted, my lord.
Yes. For there is pendency of representation of the some of the petitioners.
My lord.
Some of the petitioners being signatory in annexure 3, there appears there is no much contest in the matter, and the writ petition stand disposed by simply directing the collector Gajapati to give a lawful disposal to the representation at annexure 3, while also keeping in view the development through annexure 4 and 5.
4 and 5.
4 and 5. And let there be a lawful outcome, at least within a period of 2 months of the service of the copy.
My lord,
Strange things are happening.
my lord, since
Representation disposal, writ appeal, entertained, remanded for further consideration. LCI, CCR is not there, directed to give matter remand. Of the single judges. They are not subservient. Yes.
My lord, a similar order dated 17th August 2023 has been passed by your lordship.
Yeah, they are logistically.
No, my lord.
Kahin diyantu. Order achi diyantu.
I'll give it, my lord.
कौन ହେଇଛି ଦେଖିବା ନା ସେଥିରେ ପୁଣି ସେ ରିଟ୍ ଆପିଲ ନା ଆଜିକାଲି ତ ରିଟ୍ ଆପିଲ ଟା ନର୍ମାଲ କୋର୍ସ ହେଇଗଲାଣି
annexure
as the council wants to show order passed in similar set of matter but in different cases. Yes.
Item 14, may I please, your lords. In the episode case, I filed a miscase for correction of the cause title, my lord. Last occasion, the cause title was somehow wrong. Your lordship directed to file me miscase for correction of the cause title. I have already filed. That is the miscase number 13208.
You have already filed,
my lord. My lord, my case in brief that the
okay. Petitioner has brought an application to bring amendment in the cause title of the petitioner.
My lord.
Okay, miscase stand allowed. Petitioner is permitted to bring necessary incorporations in the cause title at the petitioner side. Hello. By in court. What is the writ petition?
Writ petition relating to shifting of the generator, my lord, which was supplied by the Sarpanch.
All right. Other day you were arguing that they are now shifting the generator.
My lord.
Generator utilized for what purpose?
For lifting of water supplied to the villagers.
Villagers for personal consumption or agriculture purpose?
No, sir, personal. Pani supply ho, pani piiba pai jo.
Pani dotule. Taku band kar dele.
Band kari deba pai chithi deichanti video by annexure 1 and 4.
All right, till you take a decision in annexure 5,
My
don't
lordship.
shift the pump.
Lordship, there, annexure 4, your lordship, there is already a direction dated
Right.
3/8/23.
Now they have an objection, but if you implement that, then they will be out of drinking water.
The reason that has been assigned to annexure 1 is that no entry has been made, your lordship. So, ଯେତେବେଳେ ତାଙ୍କୁ generator ଟା ଦିଆ ହେଇଥିଲା, no entry was made.
Record ନେଇ ସେଠି entry କରୁନାହାନ୍ତି, generator ଟା କାଇଁ ଉଠେଇକି ନେଇ ଆସିବେ?
sir.
If there is a practical difficulty, you
Lordship.
can make the necessary endorsement in your register. Even in sitting your office, if it has a purpose of utilization, why you affect the villagers? Take instruction.
Lordship.
Till that date, or else I can direct to take a decision in Annex 5. Look to page 16.
Annexure 5, the representation.
And till then, don't shift the
Lordship may direct that. My lordship.
at the submission of respective councils. The petition involve the following prayer. Taking this court to the direction at Annex 4 and the pleading in the writ application it is
Annex.
contended that the generator likely to be shifted by virtue of order at Annex 4, if shifted, will affect the consumption of drinking water by the villagers involved. Okay, taking this court again to Annex 5, it is brought to the notice that on the self-same issue there is already representation pending before the collector Baleswar. Considering the petitioners have already their grievance by Annex 5 as well as 6. Okay, this court remit the matter back to the collector Baleswar for taking a decision in the involvement of the representation by Annex 5 and 6 and taking a lawful decision in the involvement of the persons likely to be affected, at least within a period of 1 month. Till such period, if the action intended by Annex 4 is not undertaken as of now, so may not be given into operation till a decision is taken by the collector. You can advise them, authorize also. If this is a technical aspect, right? It's a public property. So some endorsement must be there. Purpose of utilization must be recorded. ଜଣେ ଯାଇକି ସେଠି ଲେଖିଦେଇ ଆସିବ ଏଇଟା ପାଣି ବ୍ୟବହାର ପାଇଁ ଗାଁର ହଉଛି ଖରା ଦିନରେ ହୁଏତ ପାଣି ନଥିଲା ତେଣୁ ପାଣିଟା ଡ୍ର କରି ଦବା ପାଇଁ ଲାଗିଛି ଆଉ ତାକୁ ଉଠେଇ ଆଣିବେ ଏଣ୍ଡୋର୍ସମେଣ୍ଟ କରିବେ ନେବେ.
As per judgment of the Sullibewa of the division based judgment, another is a Krishnadas, which is reported in 2001 OLR. In that judgment, settlement authority have no power to record the possession in column number 2 of the ROI. As per the circular of the 1986, which is Annexure 6, Circular 1988, Annexure 6, the fact is arise after the settlement operation. So I filed the representation on dated 16/3/2023, which is in running page 42, Annexure 5. My fact is, your lordship, that I purchased the land in 1970.
You have a request for correction of record of right on the basis of registered sale deed.
Your lordship, I am only prayer to correction of the possession. I am mentioning the para
correction of the
mention the para 3 of the representation, running page 42. During the settlement of operation has wrong erroneous record the bearing khata number etik jointly noted the I am the forcibly occupier since 1970, but I am purchased in 1970.
Why don't you take up the exercise section 15?
Your lordships, as because the fact is arise after the circular which is running page 43 in 1987. The fact is the new fact is arised after that circular. In that the division bench judgment regarding to that Sullibewa, which is not reported, and is mentioned in the Krishnadas case 2001 OLR regarding to that fact. That judgment also is there, your lordships. And after that there is a circular also. The settlement very clearly abolition of note of possession in settlement record. Settlement authority have no power. Very clearly in circular mentioned.
Settlement authority ko power nahi tala Annexure 5 ta so
file ta kebal consider kare pe more ye possession ta
karibe under what provision of law?
Section 41 years. Section 41 of mutation manual.
Mutation manual. Then why don't you bring a mutation case?
Representation ta ଦେଇଥିଲି
ବହୁତ କହିଗଲେଣି ଆପଣ
representation ଟା ଦେଇଥିଲି
consider ବୁଲଉଛନ୍ତି circular ଏୟା ହେଇଛି ସିଏ କରିପାରିବେନି ସିଏ କରିପାରିବେ ଠିକ ଅଛି ତହସିଲଦାର କରିବେ ତ
ଆଜ୍ଞା
so bring a mutation application.
May kindly permitted
Is permitted to withdraw the writ application in order to bring a mutation application before the competent authority. Yes, the petition is permitted, however, with liberty.
obligations.
Item 16,
Let's see, in that case, there is as per the judgment of Jagyasin Gochayat.
Demarcation case is still pending.
Yes, Lordship. Still pending 2022. There is a no 23/2022. There is a no objection of
What
the
is the
any
demarcation case number?
demarcation case
26/22.
number 26/22.
26/22. Petition establishes institution of demarcation case by page 12 of the brief. Considering pendency of demarcation case, this court direct OP number.
OP number. OP number 3, Lordship.
3.
Again.
To undertake the complete the exercise, but however involvement in the involvement of the party likely to be affected within 3 months.
Obligations.
item 17,
Yes, Mr. Rao.
My lord, for early disposal of the revision petition pending before the opposite party.
Pleading complete helani?
Not yet been taken for admission.
Not yet been admitted.
My lord.
Yes, still allegations are coming of 2020 matter not being admitted.
Pending before the opposite party.
What these officers are doing? Strange to observe a matter 37(1) OCH and PFL proceeding brought in 2020 is yet to be admitted. Considering there is unnecessary wastage of time, landing the petitioner therein in suffering. This court directs the regional authority for undertaking
OP number
admission
1.
exercise.
OP number 1.
Regional authority OP number 1 for undertaking the required exercise for admission of the matter at least within 7 days. Attempt may also be made to give final outcome in such proceeding at least within a period of 9 months.
6 months. 6 months.
Jivani, notice Jivani? Private party ochandi? How? Connected also same.
Second.
Same
Next.
20 matter.
My lord, 20 matter.
Ethi bhi 20 case number dita kar de do.
item 18,
Obliged.
Yes.
So many similar matter already disposed of in view of Narottam Ratha case, my lord. I have annexed the order.
order ଦେଇଛନ୍ତି କି?
Annexed 9.
Lordship, that this is not covered by that order.
No, but
Covered.
They have filed a miscase. That miscase may be considered on its own merit, your lordship. The order they have
That
annexed,
case is pending.
that is pending.
no. Non-acceptance of
proposed
the
mi-
miscase, man. Non-acceptance acceptance of the
Okay,
miscase.
then you may be taking help of the view of the division bench.
Lordship,
Man,
So in the process of consideration, let him find out whether this is applicable or not.
my lordship.
That's all. I had the submission of.
Annexed 9 is the civil.
No, that is not the order.
Miscase annexure kete?
Miscase annexers
Miscase
8,
stated to be
8.
pending.
8. Annexure 8.
Page. Page kuhantu, when
56.
stretching over so many pages.
56.
50?
6.
62.
Fixed 56, my lord.
66.
not 56.
56. Yes. Undisputedly, this court undisputedly find there is pendency of a miscase at the instance of petitioner. Running page 56 of the brief. Annexure 8 and running page. It is considering pendency of proceeding before the authority. This court, while directing the ASO rental colony OP number so and so to give a lawful disposal to the same, also direct taking into account the applicability of the decision in the decision of a division bench of this court in WPC 1608 of 2014 and batch decided on
2/1/2023.
2/1/2023. Yeah. Yes. By bringing an outcome, lawful outcome, at least within a period of 4 months from the date of communication of order.
Lordship, only that miscase has not been accepted yet. Lordship may only reflect that.
No, say therefore there may be a difficulty. He might not have accepted. If he is not accepting, then he has to be Directed to accept and consider.
And consider, Lordship.
Okay, okay. তাহলে উপরে গোটে para লেখা allegation through the writ application to the extent in spite of application at annexure সেটা কেটে 8
Annexure 8.
8 annexure 8 being extended to the SO OP number so and so is not accepting the same. Considering public authority cannot decline accepting an application. Deprecating such action of the authority concerned. This court direct the OP number 1. SO OP kete?
So
OP number so
OP number 2, Your Lordship.
2. To accept such application if it is extended within a period of 6 weeks, 6 days or 1 week, like the 1 week, and shall be given a lawful disposal, however, keeping in view the applicability of the decision in so and so. Okay, baki kati do. Right.
others are same.
That's why more say single order ta say diya utala.
Lordship.
Others are same. Others are same.
Sab samana. Right.
Item 19.
କାହିଁ ତା ମନା କରିଦଉଛୁ କହୁନାହାନ୍ତି ତାଙ୍କୁ instruction କଣ ପାଇଁ ସେ refuse କରିଦଉଛନ୍ତି?
No, I had instructed a few times, Your Lordship.
Unnecessary litigation High Court କୁ ଆସୁଛି ନା?
My Lordship.
Revision petitions are pending.
ଅଲଗା ଜିନିଷ whether it will be allowed or not, that's a different aspect. It's to be entertained, registered and a lawful disposal.
My Lordship.
Yes, what is this case?
Revision petitions are pending for fresh admission.
Fresh admission. 21 ରୁ pending ଅଛି. Fresh admission and disposal within 9 months. Fresh
Item
admission
20.
1 week. So all these batch same order. Okay, all right. Yes, 20.
Here, the dispute between the private parties matter, the revision was filed by the revision petitioner on 21/11/2001, that is annexure 3, page 18. There was limitation. The order was passed to issue notice on the question of limitation. Page 18, my lord.
Page 18.
Again, 21/11/2001.
Yes.
No notice was issued, then case was transferred, and again, directly case has been admitted. No notice is issued either in limitation or in.
You are a party. You are a
Yes,
party
yes.
to the proceeding.
Yes, madam. We are OPs 1, 2.
And it is expert again.
Again.
Annexure 4 is the impugned order.
Impugned order and subsequent order is annexure 6. I am OPs 1, 2, 4 and 5 in the active case. No notice has been issued.
And you have filed a miss case there.
Madam? No. Madam, after remand by the commissioner annexure 4, the revision petitioner filed miss case and miss case order has been passed in their favor. I challenge the impugned order on annexure 4 where no notice was issued.
But in the meantime, the matter has been remanded.
Matter remanded expertly and also disposal by the Tahsildar, annexure 6. Both annexure 4 and 6 I have challenged.
6 also, there is already an outcome.
Again, that
And
is
in
page
the-
32.
In the proceeding by 6,
Again.
are you not a party?
Yes, I am party. I have filed objection. We have not been noticed in the
No,
revision.
that was not the consideration.
Again.
Was it available for consideration of the remand
No,
authority?
no, madam.
So what is the meaning of this objection?
Again.
So how are you affected by annexure 6? Is it a contested order or not?
No, my lord. Annexure 4 is the expert order.
Annexure 4 expert, it is well understood. You have said.
Annexure
Repeatedly
6
saying that.
Annexure 6
So
is
by
only
annexure disposal under annexure 4, there is a remand order.
remand order. No, remand for recording the
And
name.
annexure 4 was a 15B.
No, annexure
So
4.
there was remand to Tahsildar.
No, revision was allowed and kindly come to page 25. Order was passed to Tahsildar to record the suit land in the name of revision petitioners. Page 25.
Page
25, ma'am.
25.
Okay, revision petition is allowed. Tahsil Darpan is direct to implement order on the basis of my above observation.
Then why did you participate in the annexure 6 proceeding?
Oh, after notice. Yes, ma'am.
যদি surrender করিগলে and outcome has come, then you have to find out against that order only. Because there is no merit disposal in annexure 4. It is just a remand order.
It is allowed, my lord, to record the.
Annexure 4 is not allowed.
Yes, my lord.
Or revision petition is allowed.
Allowed, not remanded.
Then you said just now it is remanded.
No, allowed, my lord. Sorry, my lord. Revision petition was allowed.
ନିଜେ confuse କରୁଛନ୍ତି.
No, sir, allowed.
Okay, private party there.
Okay.
Notice ନିଅନ୍ତୁ. Issue notice on petition of admission. ଆପଣ ନିଜେ କେମିତି confuse ହେଇକି ରହୁଛନ୍ତି?
Sir, sir.
Miss case ରେ notice କରିବ and there shall be status quo in respect of the dispute.
Item 21.
Yes, Mr. Koro, long after.
May it please your lordship. Mothos Lane.
Not to inaugurate the new bus stand.
New.
ଆଜି କାଲି inaugurate ହେଇଗଲା ବୋଧେ?
ଏଟା ମୋର
ଏଇ ଯୋଉ 27 ଟା bus stand inaugurate ହେଇଛି?
ଏଟା ମୋର information.
ହଁ ସେ ସରିଗଲାଣି, infructuous ହେଇଗଲା.
Not to inaugurate, my lord, my land has been forcibly taken away.
ଯାହା matter ଥିଲେ ବି ଆପଣ କେବଳ inauguration ନ ହଉ ବୋଲି କହୁଛନ୍ତି. ଆଜି ସକାଳେ ଆମେ ସମସ୍ତ ପେପରରେ ଦେଖିଛୁ 27 ଟା bus stand inaugurate ହେଇଛି. In one go. So if this is already inaugurated, କାଲିକି ଆଣୁଛି ଆପଣ କହନ୍ତୁ, ଆପଣ ବି ଦେଖନ୍ତୁ.
My only preliminary objection is that they are praying for a writ of mandamus. However, no representation has been filed.
ଆଜ୍ଞା infructuous ହେଇଗଲାଣି ମ୍ୟାଟ.
I'll take instruction, Lordship.
ହେଲା instruction ନିଅନ୍ତୁ ଏ bus stand ଟା inaugurate ହେଇଗଲା.
Lordship.
Otherwise also there is no case. ତାଙ୍କର କିଛି personal land acquisition ହେଇଯାଇଛି ବୋଧେ. ଆପଣଙ୍କ land ରେ କରିଦେଇଛନ୍ତି bus stand. ଆଉ bus stand ତିଆରି ହେଇକି inauguration ହେଇଗଲା, ଆପଣ କଣ କରୁଥିଲେ?
Without any notice, in the earlier direction, my lord, I quoted the order. Your lordship's order, I.
ଆଗରୁ ଆସିଥିଲେ.
ଆଗରୁ ଆସିଥିଲି. At page, paragraph 5 ତଳକୁ, my lord's order, I quoted also.
No, that is a different issue. That is some mutation proceeding was pending.
Mutation proceeding because.
So correction of record of right ଥିଲା, ସେଟା ଅଲଗା issue ଉପରେ ଅଛି.
And my lord's order, I communicated also before the learned.
Come with a better application, Mr. Koro. What is there to fight in these issues? Can there be a mandamus issue not inaugurating a new bus stand? It is in the larger interest of the public.
Since the DT's land is being forcibly taken without permission of the endowment.
That is a different issue. You can bring appropriate litigation. Why are you pursuing? Had the submission of Sri Koro and Sri Mishra. Writ petition involved following prayer. Look into the main grievance involved here in this court, find no purpose will be resolved in the assisting of the petitioner in entertainment of the writ application. Looking to the narrow demand involved herein. In the circumstance, this court though find no purpose in entertaining the writ petition and dismissing the same, however, observes in the event petitioner has any substantial grievance, it is open to the petitioner to bring appropriate litigation.
I pray before your lordship.
Subhani, a mic tolu karan.
I pray before your lordship that since the DT's land is being forcibly taken away, I only stick to that portion, my lord. Regarding reopening, I am not pressing that thing.
How come prayer ଅଛି?
I would prayer ଅଛି said without leave of this honorable court, since the DT's land is being
not to inaugurate the new bus stand without leave of this court, since the details of land is being forcibly taken. Sorry, sir. ଆଣନ୍ତୁ ଆପଣଙ୍କୁ liberty ଦିଆହେଇଛି, ଅନ୍ୟ matter କଣ ହଉଛି ଆଣନ୍ତୁ.
Your my lord, I stick to this that.
ଆଜ୍ଞା ଆପଣଙ୍କ ଆହୁରି ସୁବିଧା ହବ, ଧରନ୍ତୁ bus stand ଟା operationalize ବି ହେଇଗଲା, ଆଜ୍ଞା ମୁଁ land ନେଇଗଲେ article 300 violate ହେଇଛି, at least ମତେ compensation ଦିଅନ୍ତୁ. ହବ ନା ନାହିଁ?
DT's land
judgment ଦେଖନ୍ତୁ.
Because my lord, your lordship has directed 2.5 months.
Yes.
To the Tahsildar.
Next case, that's all.
Item 22.
May it please, my lords, I appear on behalf of the petitioner.
Yes.
My lord, may kindly have page 29. And page 29 refers to the order of the MSEFC. The petitioner before the MSEFC is one Messrs. S.J. Biz Solutions. My lord, may kindly have top of the page of 29. Messrs.
You are challenging Annex 2.
My lord, I'm challenging two. I'm challenging the notice as well as the order. This notice is for initiation of conciliation proceedings before the MSEFC. Now, my lord, may kindly note that the petitioner before the MSEFC got itself registered under MSEFC, under the MSMED Act on 4th of December.
Bhattacharya.
Yes.
There is some technical difficulty. Where is the certified copy of Annex 2? It's an impugned order.
My lord, we have placed whatever we have received by post, my lord.
No, this can't be by post.
I am in Pune. So I have challenged it basis whatever I received by post.
No, it can't be received by post. This is just a Xerox copy. There must be.
Yes, that is what we have received, my lord. We have not even received the claim petition.
That must be a signatory one.
All we have received, my lord, is what we have produced. We have not received any certified copies. We have not even received the claim.
No, I don't mean by certified copy. At least a communicated copy.
This is the communicated copy, my lord.
No, this can't be. This can't be.
My lord, may kindly have page 27. This is the notice.
So this is Xerox copy of notice, Mr. Counsel. You are not understanding. This is all Xerox copy, not the in original. A notice never sent in Xerox format.
My lord, once
signature of the administrative officer in Xerox even. It's impossible. Bring the original of Annex 1 and 2.
Very well.
And there must be defects shown to this effect. So how much time you want? Yes, there is defects shown also. How much time you want?
2 weeks, my lord. 2 weeks should be good enough because we are in Pune.
Matter 2 weeks. The counsel for the petitioner is directed to bring at least communicated copy of Annex 1 and 2 for maintaining the writ application.
Deeply obliged.
Yes, next.
Item 23.
Yeah, Mr. Bhattacharya. Yes, 23.
May please, your lordship.
Yes.
That
Senior counsel appearance.
lordship, may turn to page
What is your prayer here?
No, prayer is the land on which my school runs, my lord. It is, lordship, just sees page 24 and 25.
GB again.
It will make
slow jiba. Slow jiba. Senior counsel ଯେତେବେଳେ ହଉଛନ୍ତି ମୁଁ ଟିକେ doubly cautious.
ଏଇଟା ଖାଲି ଦେଖେଇଦେଲେ clear
ଟିକେ slow ଯିବା.
ଏଇଟା ଦେଖେଇଦେଲେ clear ହେଇଯିବ ପ୍ରିୟାଟା.
ନାଇଁ clear ହବ ମୁଁ ଜାଣୁଛି ମୁଁ ଅଛି I am on some other issue. What
Aye.
is your prayer?
The prayer is
Why the government land being used as playground shall not be allotted to the petitioner school further to Annex 4
Yes.
and based on the advisory of central government by Annex 10.
Yes, sir. That's all.
Okay. Right. Then who are you?
But I am the school, my lord.
You are the school.
Yes. But this is the reason
the crux of the matter.
Yes, what I want to point out, your lordship, my lord.
Okay, now come to your document.
Yes, at page 24, my lord.
But yes, page 24.
That is the record of right, my lord, with regard to my land, my lord.
The record of right in the name of Sanskrita Siksha Sansthan.
Yes, that is the society under which the school is running, my lord. Then lordship kindly turn.
But you are Bharati Vidya Mandira.
Yes.
You are an institution under this society.
Yes, my lord.
All right, then
lordship come to page 26, my lord.
20?
This will make the thing clear, my lord.
27.
26, my lord.
Yes.
That's a sketch map, my lord. Your lordship will find there is a big chunk of land towards the bottom, my lord. 2407.
Yes.
And within that big chunk of land, this school situates 2588, my lord.
Yes.
But this is the government land and this school is situated inside. And the land nearby, was being used by the school as a playground for the children, And then I had applied long back for the purpose of giving some land to me for the playground. Lordship turned to page 27.
Yes, there is a recommendation for
By the, yes, GA department asked the Mass and School Education Department.
But is there any mentioning of this plot number?
No, here there is no mention of the plot number. I have written a letter on 1/12/86 to from the GA department.
Is that letter available?
This letter, yes, is available with them.
On the body of the petition or not?
Yes, Annexer. Annexer 4, that's Annexer 4 I'm mentioning.
No, the letter there is a reference of your letter.
Yes.
And how do we find that this is the plot involved there? It's only approval. There is no dispute in that. That this land has been given to you.
Yes.
How do you connect it?
But I just, through this, Lordship, I come to page 7, paragraph 6, that the petitioner further submits.
Yes.
That in the year 1986, the school authority had requested the opposite part number 2, the J department, for allotment of government land in favor of the petitioner school. Basing upon such request, the opposite party number 2 had forwarded the letter to the Mass and School Education Department seeking departmental view for allotment of government land to the petitioner school.
That's right. You are only, it is all evasive.
Yes.
There is no reference to plot anywhere.
Yeah, I agree with that. I agree with that.
In the drawing, you are only bringing the reference of
Yes,
the plot
yes,
number.
yes, yes, correct.
So now there is allotment of this land. How do you establish again?
But in fact, other than the land which has been recorded in my favor and the land on which the school runs, there is no other land allotted to me, my lad. But I was having the
by which order there is reallotment of this land to?
Now this land has not been allotted to anybody now. But the BMC wants to, whatever construction is made for the purpose of playground, the BMC comes forward to demolish. They have not only demolished, they have started construction for their ward office.
For their ward office.
Ward office.
They may be requiring a very small piece of
Yes,
land.
exactly, Milan. Why such a big part? I showed to Lordship that is the reason. Such a big chunk of land, they can have their ward office somewhere else, but they should leave some place for the students to play. Lordship will kindly see the guideline of the Government of India at page 45, Milan.
Yes.
Milan, the ministry has received representation
for your submission.
Yes.
Okay, there is some infrastructure necessary in and around the schools. There is no dispute.
Yes, I got.
So question remain here. For your submission, construction is already undertaken.
Yes.
So
let them have construction somewhere else and give some land to me, Malad. I don't require for any other purpose, only for the school children.
Where have you stated you are in use of this particular
Yes,
land?
yes, Malad.
With plot number?
Now that I have space.
ଏଠି ସବୁ ସ୍କୁଲ କାହିଁ କରି ପକଉଛନ୍ତି ଆପଣଙ୍କ ନିଜର ଜାଗା ନଥାଇକିରି ତାପରେ ସେଠୁ ଆପଣଙ୍କର ଆସିବ
education.
Therefore you
And
should
from
be
the
careful when you construct a school.
And in fact, the inmates of the jail.
Undisputedly, it is not your land. Of course, land officer has already given a order for that. Order was when Annexure 4 was passed when 87.
Yes. Now, not down.
And thereafter, there is no allotment.
No allotment, nothing.
Therefore, you are sleeping just over the matter.
But now, in fact, we have been trying our best to find.
Notice on the question of admission. Things were written about it. Okay, next lecture. The petitioner appears to be claiming his right over the plot number
2407.
2407.
Yes.
2407.
Around 2588.
Adjacent to.
Yes.
Own plot 2588.
in his use of the school since long and on the purported support of an order of the land officer issued since 23/4/87 appearing at annexure 4 and allege, in spite of such a recommendation of the land officer and in spite of the fact that the school is in use of such land, there has been attempt by municipal corporation in coming out with construction of a ward member office in a parcel in a portion of the land involved. This court on the basis of annexure 4 finds fantasy satisfied with the claim of the petitioner and needs examination of the matter, accordingly direct issuing notice. Miscase on the own submission of Sri S.S. Das Senior Counsel, the Bhubaneswar Municipal Corporation has already commenced construction of a ward member office on a limited portion of the land. Okay, while directing issuing notice in the miscase also, this court also direct maintenance of the ballot status quo. So far it relates to the balance land out of plot number
2407.
2407. এটা ଆଉ କଣ ତାର ଆଉ କିଛି description କିଛି ନାହିଁ
ସେଇ sketch ରେ ଯେତେ ଖାଲି ଅଛି
ଏଇଟା ତ ଖାଲି map ଟା
ଆଜ୍ଞା
ଏଠି କୋଉଠି ମୌଜା କଣ adjacent to plot number 258
Millard, it is in para 5 have mentioned Millard. Moja Jharpada, Sabik plot number so and so.
Okay, para 5 ରେ ଲେଖିବ ଦେଖିକିରି yes para 5 ରେ ଅଛି. Okay, all right, till the next step. Yes.
Item 24.
Mr. Das, you are sure they have broken open the wall, compound wall?
Yes.
It is already walled.
We had a wall Millard there.
Okay, by breaking open the compound existing, by breaking open the existing compound wall and started commencing construction of a ward member office. Yes, all right.
Millard, item 24, it is a covered matter. I have filed the orders of this honorable court at annexure 8.
Page kete?
Page 67 to 70.
All right, similar matters are being.
Seems to be covered, my lords, but only one aspect I would like to point out. It has gone through many sale deeds, your lordship. The original lease case was in 1960s. After that, 3-4 hands it has changed. So lordship may only observe that a decision may be taken based on all these sale deeds and reports, your lordship. Because all those sale deeds have not been annexed in this writ petition.
That aspect has been dealt with in the original.
Hey, this is simply remand of the matter. This is simple remand of the matter, then it will be decided in accordance with law.
Lordship.
It is remitting the it is annexure kete hobo se?
Millard, annexure 8.
Impugned order annexure kete?
Annexure 1.
1.
Millard.
And so it is Sampur opposite party, Sampur Moja. OP3 again.
Millard.
Here also OP3. Sampur Moja ASO dekhiwala to take a decision, lawful decision.
OP number 2, your lordship. OP number 2.
2. OP number 2. For bringing out a lawful disposal.
Assistant settlement of some.
Item 25. My lord, this is a matter regarding non-payment of admitted dues.
Pending achi.
Yeah.
Annexure 3 is pending.
Annexure 3 pending.
Annexure 3
non-payment of admitted dues.
Bill ortho.
Yeah.
All a prayer quote kar de annexure 3 directed to be decided by OP number
5.
5. Seppo kai logo. ତେଲ ଲଗେଇବେ
ଆଜ୍ଞା ଏଟା ପେମେଣ୍ଟ ଦେଇନା
ନହେଲେ ସେଠି ଗୋଟେ ଥୁଆ ହେଇଛି ଦେଖିଲେ ପାଣି ଲଗେଇକି
ଥିଲା ଉଠେଇ ଦେଲେଣି।
ତ ନେଇଗଲେ କୋର୍ଟ ମାଷ୍ଟର there is allegation you have taken out that ତ ରଖ
ସେଟା ଆଡମିଟେଡ ଡ୍ୟୁଜ ଟା ପେମେଣ୍ଟ ଦଉନାହାନ୍ତି ଆମକୁ।
କରିଦେଲି ପରା
ଆଜ୍ଞା
direction ଦେଲି consider କରିବେ your representation within 1.5 month
ସେ
and
already
payment if any there is entitlement of payment if any should also be released within 1 week thereafter
5 and 7 opposite of 5 and 7
5
5 and 7
5 and 7 working together hala next
Item 26.
ତାକୁ copy ଦେଲେ ପରା
Yes, ma'am.
okay what is this matter
Matter, my lord. My lord, as very simply put by my learned friend, it is not that simple. This is a commercial contract of PPL which gives a transportation contract for gypsum lifting. So earlier they came up before your lordship and took a direction for the ADM to consider the representation, who has no role to play so far as the business affairs of the company is concerned. And they took a direction from the ADM that to consider to give them the work as it was being given earlier. So that we have also communicated to them, rejecting that we cannot, it cannot be monopolized. There cannot be a single retailer or like person who can do it. We have communicated to them, they have not challenged that order. And the prayer is to implement
ANSO 4 is opposing them
my lord.
ANSO 4 is the ADM order
ADM order.
that is opposing them
No, not I'm sorry. Annexure 2, my lord. My read petition, Annexure 2. Annexure 2 is the direction 15 from page
that
50.
is the direction sought for working out
Yes.
that is the direction they are seeking working out
Working
yes,
out. So which we rejected. We said it cannot be monopolized. There are multiple.
where is that rejection order?
No, that they have not.
No.
I have communicated, they have received.
I may be allowed to, my lord. Pursuant to order of this honorable court,
now he has taken a decision
in presence of both the parties.
right
Yes.
again landing in a direction to them. What is the direction? Read direction by ANSO 4.
Annexure 4, that is the communication of the ADM.
What is that communication?
The undersigned has received a petition from.
I am to request you to take a action in the light of letter of the undersigned communicated to you Vaid. Now they say yes, they have taken a decision.
And we have communicated.
And in the rejection.
Yes.
And have communicated that.
Directed to the ADM.
So will you
to consider.
challenge that or not?
My lord, this honorable court directed the ADM to consider my case. PPL has, now I came to know from the caveat, PPL has rejected my representation.
So you will correct
that
it.
has not been communicated
So
to me. That has not been communicated.
Or you will bring proper challenge or not? ଜାଣିଲେଣି ତ caveat ରୁ ଯେ rejection ହେଇଯାଇଛି ବୋଲି
Rejection PPL କରିଛି ଆଜ୍ଞା
PPL କରିଛି
PPL କରିଛି
challenge କରିବେନି ଆପଣ
party to the case. He is the party to the case.
ଆପଣ ଆଣନ୍ତୁ affidavit
We'll file a reply.
File affidavit, I'll pass appropriate.
Yes.
What is there? He is not interested in bringing amendment. He can very well challenge your order also.
Amendment, yes, my lord.
And ADM cannot.
ଖାଲି amendment ହବନି, reading ବି change ହବ,
pleading change ହବ,
order ଆସିବ, so withdraw କରି better application ଆଣନ୍ତୁ.
Yes.
Now that you have come to know there is further cause of action.
Yes, ma'am.
Why are you pursuing this?
Thereafter, what I came to know from the cabinet.
Sri Das and Sri Das, Sri Nanda, Senior Counsel, and Sri Mishra. Okay. Read petition involved challenge to the order at inaction of the opposite parties to act in accordance with ANSO 4. On his appearance, Sri Nanda, learned counsel, bringing through the caveat application, brings to the notice of the court that there has been further cause of action involving ANSO 4 by way of rejection decision against the petitioner. It is in under the submits, there has been shifting of cause of action. Okay, it is in this circumstance and at this situation, Sri Das Learned Counsel appearing for the petitioner seeks withdrawal of the writ application to bring a better application for consideration of the court.
So, sorry to one thing, that lordship, on Annex 4 operating person, that order number so and so dated 1906, that is the order of the ADM. That is not order of the.
No, that's a mandamus. That's a mandamus. There is no discretion with the authority. Is it a read court order so that they will be obliging?
And it is a purely
administrative
private
order they have considered, Mr. Nanda. He still argues negative. You can bring, nobody prevents you. You can still have your remedy through Annex 4, provided you challenge that and overcome that. আমি ଏଠି ବସି କ୍ଲାସ କରିବୁ କହିଲେ ଆପଣ କେମିତି ହବ? ଆସନ୍ତୁ ଆଉ 15 ଦିନ ପରେ ମୋ ପାଖକୁ। ଯାହା ହବ।
Item 27.
Yes, disposal of appeal.
May I please, Your Lordship?
Mutation appeal is
Yes, Your
pending.
Lordship. In both the cases.
OP4.
OP2, Your Lordship.
OP2 OP2 directed disposing mutation appeal. Number of the respective case they give a different number. Huh? Okay, at least within a period of 3 months. But however involving the pleading complete is
Yes, Your Lordship. We are ready.
Record over pleading completed. Right.
Item 28.
Item 28, may I please, Your Lordship?
Yes.
My Lordship, in this present petition, the petitioner challenging the inaction of the opposite party number 3, the Tahsildar Bhubaneswar, in not mutating the land for last 10 years, my Lord.
Not?
For the last 10 years, the application is pending. In the meantime, they have applied other two applications has been filed, but still no action.
Any mutation registration there?
Yes, my Lord. Case number is there. One receipt of
Page,
rupees
page.
55 has been issued by the Annexure 3, my Lord, 42, page 42.
That is receipt book. So you submit by this deposit, you have made a mutation petition.
Yes, my Lord.
And that is pending since 2013.
Yes, my Lord. After that, 2014, I have filed another petition. Then again on 2019, I have also filed another petition.
Take instruction. I am taking this matter next week.
Lordship.
There's a serious allegation involved here in that even though the mutation proceeding is instituted in 2013. Persons to deposit by Annexure 3. There has been no outcome shown as of now. The Annexure 4 series re bhi achi.
Yes, yes, my Lord. And Annexure 5, my Lord, in Annexure 5,
that is another application.
No, my Lord, that certified copy of the two applications, mutation application filed by the present petitioner has been solicited regarding the order copy in Annexure 4. And in Annexure 5, my Lord, RTA application filing the total.
That will be taken care of there. এটা ଆଣିଛନ୍ତି ଆପଣ action show କରୁନାହାନ୍ତି ବୋଲି ଆପଣ RTI ରେ information ମାଗିଛନ୍ତି to know what is the cause action there.
Yes.
So ये instruction ନିଅନ୍ତୁ ଦେଖିବା.
Lordship.
Place this matter on next Thursday. In the meantime, let there be service of 2 copies on the State Council who is directed to take instruction as to the reason in delay in undertaking such exercise. From the Tahsildar ki OP number?
OP number 3, my Lord.
OP number 3.
Obligation.
Place the matter on next Thursday. Yes.
Item 29.
May I please, my lords?
Yes.
My lord, here the petitioners pray that the proposed SSG hut may be constructed at any place other than the petitioner's place, that is 445 and others. Because with respect to that, my application under WE Act seeking to accept me as a deemed tenant and fix up fair and equitable rent is pending.
Is still pending.
Is still pending. My
What
application.
was your earlier writ petition?
There
Number
are
of writ petitions are there.
5 writ applications I have come before your lordship protected me.
Probably in some writ petition there is status quo order continuing.
My lord, what did they do? Annexure 33, your lordship passed the order. Thereafter, what did they do? That they directed that the construction may be done by R&B. R&B was not party in that writ application.
Status quo means the nature and character of the land may not be changed.
That should
Whosoever
be.
may be the
That should be.
That's true. So,
but I need a protection from my lord now.
where is your pleading that involving self-same land? First of all, you satisfy that this is the same land involved in the OEA proceeding.
My lord.
And then pleading will be required to establish that there is a OEA proceeding pending. OEA lease case 351 of 74.
My lord, OEA case number 351 of 74.
That is pending.
That is pending. I have annexed to that.
Why it is pending since 74?
They are not proceeding. There are series of actions.
What were the cause of action in the writ petitions?
Present writ application.
No, earlier writ petitions.
The earlier writ application, your lordship may kindly look.
There was attempt for demolition.
My lord.
So
your lordship may kindly come to the date chart.
Right, I have come to know there have been several, and the earlier writ petition also in the involvement of municipality.
Municipality.
Now it is against municipality.
Yes.
So
no, one thing your lordship may kindly have a look to the prayer itself first. He has referred to number of writ petition, including the latest writ petition which was withdrawn at the instance of the petitioner to pursue a revision because that writ petition was against an order passed in the OSS appeal, and thereafter they withdrew that writ petition and they have preferred a revision, and that revision is sub judice.
So in the sub judice of so many proceedings, will it be appropriate to go ahead with construction of
stand recorded in the name of government?
Maybe then what will happen? Yes, tomorrow there may be a resolution through court. If you go ahead with construction, then you have to undertake, you will take out, remove all these construction.
My lord, in that event, Lord, they had earlier approached this honorable court against the order of appeal, and they themselves on their own, they have withdrawn it and preferred the revision. Revision is very available.
Revision is pending, so an outcome is expected.
Yes.
So suppose he succeeds in the revision, what will be the position of the land?
It will be restored to him.
It has to be restored. See, will it be appropriate spending public money and restoration of the land again?
Exactly. Now, my lord, your lordship
So
sees
therefore-
that interim order which was passed, it was for a limited period.
Forget that. You do admit the pendency of the OEA proceeding and revision order.
But that I will have to take
Then-
instruction.
And who will be affecting? Municipality will be affected.
Let the municipality.
You don't bother. You don't bother.
My lord, I draw your lordship's attention to your lordship's order under annexure 33,
Page 284.
page 284.
Two
84. First title रे भी से प्लॉट गुड़ा का सब अच्छी हमें दे
445 ରେ ଅଛି। ତାପରେ ହଜୁରଙ୍କ ଅର୍ଡରଟା ଅଛି 227 ଏମାନେ କଣ ତିଆରି କରୁଛନ୍ତି municipality?
ସେଟା ହାଟ ଗୋଟେ ତିଆରି ହେଉଛି SSG ହାଟ. That is also for the interest of public.
No, interest of public, but not at the cost of the private owner.
No, private owner
He
provided
has a right. He has a claim pending. He has a claim pending. You can wait. You can find out some other place.
Your lordship may kindly come to page 287.
Page
287.
ସେଇ କେସ୍ ଅର୍ଡରଟା
এই কেসরে আপন এই অর্ডার দবারু আমি যাইଛୁ had learned counsel appearing for the petitioners, learned counsel for the petitioners pray for withdrawal of the writ petition with liberty to petitioners to file a revision for petitioners bona fide approaching this court having efficacious remedy. Petitioners are provided 4 weeks time.
Right, ଦିଆ ହେଇଥିଲା ଆପଣଙ୍କୁ liberty ଦିଆ ହେଇଥିଲା।
ତାପରେ ଆପଣ ସେଇଥିରେ ଲାଷ୍ଟ କୁ ଲେଖିଲେ
କୋଉ provision ରେ?
till a decision is taken in the interim application there shall be status quo in respect of the disputed.
ନେଲେ କି interim order କିଛି ହେଲା ସେଠି
କିଛି admission ହେଇନି ସେଟା
ସେଟା ଚାଲିଛି pending ଅଛି
ସେଟା ଚାଲିଛି କିନ୍ତୁ ଅଛି ମୋର ଗୋଟେ decision ଅଛି in the interim period what will be position of the land
on land
that protects you.
ଆଜ୍ଞା
Yes, Mr. Bose, let notice go.
ଆଜ୍ଞା
Construction ଯଦି construction already commenced
Yes,
ହେଲାଣି
yes.
କୋଉଠି ନା ନା construction comment that I have
ଯୋଉ ଘରଟା
I am
ଭାଙ୍ଗି ଦେଇଥିଲେ
observing
ସଫା
if
ହଉଛି।
there is no construction commenced as
No,
of
no.
now, let it be
ସେ ମୋ ଘରଟା ଯୋଉଟା ଥିଲା
stalled for
ଭାଙ୍ଗିଥିଲେ
1 month. Let them appear thereafter will decide.
କେଉଁଝର municipality ତ ପାର୍ଟି କରୁଛନ୍ତି ସେ
ସମସ୍ତଙ୍କୁ ମୁଁ ପାଟି
Considering the submission of senior counsel, Vidyadhar Mr. Senior Counsel, that there should not be any construction undertaken over the disputed land. Koti property schedule ଟା ଅଛି କେତେ page ରେ?
ଆଜ୍ଞା
cost title my lord ଅଛି
Schedule of land so and so.
cost title my lord ଅଛି
There should not be any construction over the scheduled land so and so until unless there is closure of the OEA proceeding and as well as the revision proceeding
Cost
pending
title.
involving the self-same issue. This court find there has been repeated orders, there has been several approaches to this court and sometimes this court even granted status quo in respect of the disputed property. Matter request examined. Taken place, because accordingly for the state of Santa Gupati, by Monday, matter will be listed immediately after, at least 3 days after the, or 7 days after the date of appearance expires. In this case, the notice as above, this court records the statement of Sri Misra that there is no construction undertaken as of now involving the disputed land. In the above scenario, this court observed, provided there is no construction commenced as of now, there should be status quo in respect of the disputed property indicated here in above for a period of 5 weeks. The date as above, 5 weeks without a date there. Okay, 3 days after କହିଛି consequently ସେମାନେ date of appearance fix କରିବେ ଆଉ
urgent certificate
Pardon?
urgent certificate copy
urgent copy ଆଜି ମିଳିପାରିବନି
ସୋମବାର ମିଳୁ କାଲି ମିଳୁ
ଆଜିକାଲି ଆମେ ଆଉ ଲେଖୁନୁ urgent copy ଆମେ ତ next day ଦେଇ ଦଉଛୁ ଆଉ ଅପଲୋଡ କରୁଛୁ ଆପଣ ନେଇ ଯାଇପାରିବେ ସେଥିରୁ ମଧ୍ୟ
ସେଠି କଣ କି ଅର୍ଡରରେ ନ ରହିଲେ ରେଜିଷ୍ଟ୍ରି
ଦବା ଆପଣ ଆଜି affidavit ଦେଇ ଦଉନାହାନ୍ତି
ଆଜ୍ଞା
Considering grant of certified copy will take some time, it is petitioner is with liberty to provide a communicate the interim direction to the municipality involved herein by way of affidavit. Yes.
Item 30. May I please, Lordships. My Lord, my case is covered by my Lord's decision.
It's covered.
Obliged.
Item 31.
May I please, my lord? My lord, here in this matter, your question of law involved, my lord. When the base of the order gone, all the consequential orders also gone, my lord. My lord, here, my lord, Annexure 5 is impugned before your lordships, which was passed based upon the Annexure 2, and under Annexure 3, at running page number, my lord, Annexure 3 starts from running page
You
number.
challenge Annexure 5?
Pardon, my lord?
You challenge Annexure
Yes, my
5?
lord. That is consequential to Annexure 2, which your lordships pleases to set aside under Annexure 3.
Just 1 minute. It appears to be ex parte order.
Yes, my lord. This is ex parte order. And my lord.
What is the reason of your non-appearance?
Yes, my lord. I have not received any notice, my lord. That averment I have taken. My lord, very promptly they have passed the order, my lord.
Annexure 5 is a proceeding initiated following the direction of this court.
No, my lord. Annexure 5 has been passed basing upon the order passed under Annexure 2, which was impugned before this honorable court in earlier read. And that order, your lordships pleases to set aside under annexure 3 of the present writ petition.
Sir, remand revision. Remand revision.
Remand revision.
Remand revision, but I find it is expiring.
Yes, it is expired.
So कौन करे remand कर दो
My lord, that is, my lord, section 32, your lordship dealt with that matter, that revision under section 32 is not maintainable under the OSS Act. On that order, this case has been, this annexure 5 has been passed. Being remanded from the annexure 2, this order has been passed. Hence, this order annexure 5 is consequential to the annexure 2 that your lordship pleases to set aside. My humble submission is, when the base of the order had gone, this consequential order has no force under law. And I am relying upon 3 Supreme Court judgments, my lord.
Just 1 minute, 1 minute. Annexure 5 was passed on 1/6/2013.
Yes, my lord. That is,
this High Court passed order when?
This High Court passed order under, it is 14/7/2022.
By this order, annexure 2 is taken away.
No, my lord. Yes, this order annexure 2 has been taken out.
To annexure 2.
Annexure 2, my lord.
Mr. Ghosh, there is some other issue involved.
Yes.
Now, annexure 2, a proceeding under section 32 of OSS Act was decided
2013.
2013.
After remand.
This is decided after remand.
Yes.
Last portion the impugned order therefore appears to have been arbitrarily passed by the appellate authority, which is violating the principle of natural justice fraud. Being the main allegation, the appellate authority ought to have examined the claim of the appellant properly before dismissing the appeal. Accordingly, according to various decisions, so and so on. From the above discussion, there is sufficient reason for revising the arbitrary order passed by appellate authority. Revision being admitted, the impugned order, so it has gone back to the appeal stage.
Yes.
It has gone back to the appeal stage.
My lord.
This order, annexure 2, it has gone back to the appeal stage.
My lord, please just.
Or they nomenclate it as revision petition. Section 22 stage ko wala.
32. 32.
No, 32 re decide ala.
My lord had
decide remand kale.
So treated as an appeal under section 22 of the Act.
Yes.
So 22 ta normally revision.
Again.
So order now annexure 5. You say it is an outcome of this order.
This annexure 2. Yes, my lord. Which my lord pleases to set aside under annexure 3. Running.
Confused korchandi.
Sorry.
Annexure 2 came to be challenged in a writ application.
Yes, my lord.
Writ application has already set aside annexure 2.
Yes, my lord.
In the meantime, when the basis of annexure 2 order, there is already order in annexure 5.
Yes, my lord.
So once annexure 2 is set aside,
yes, my lord,
annexure 5 should automatically go.
Yes,
that is your
my
submission. You are making confusion.
My submission would be the stage when the present petitioner came up before this honorable court. By then, that order had already been acted upon.
This order was already there.
Yes, and this order now,
but it naturally died. There is no need of challenging even. If annexure 2 goes,
yes,
there is no
need of challenging this order.
There is no need of challenging.
Annexure 5, that is what I'm saying.
This is to automatically die.
But my lord,
बुझो ना आपण बुझामणा ठीक है आपण टिके माने लैंग्वेज रे कंफ्यूजन है जो
my lord, अभी
ठीक है ताले आपण काई चले I can only observe this order become innocuous is not to be acted upon even. So I am closing.
এটা খালি
কালি কানিবা देखिबा उतरे
হাটা কালি আসু
settled principle
আসু
না না সেটার সেটেল প্রিন্সিপল বুঝিলি কিন্তু এটা হচ্ছে গোটে অ্যাকশন যেটা which is no more in existence.
That's right. Once
after being acted upon, মানে my submission was once it was acted upon in 2013 on remand, so the no more that order existed, my lord.
But once yes, that's right.
So therefore, my lord, once the challenge itself, without incorporating this order, consequential order. So that's what happened. In 2022, the order which he obtained.
Mahanti,
My
Mr.
lord.
Mahanti. You are Mr. Mahanti, na Shiv Shankar.
My lord,
Mr. Mahanti, you have to make it clear, the annexure 2 set aside here
my lord.
in the read petition, is this annexure 2?
Yes, my lord. This annexure 2. It has been mentioned in page number, my lord. Please just to observe in page number 30, my lord. That 31 is the relevant page.
So while
The
this
same
annexure was moved,
Sorry, my lord, sir.
that's what happened. Challenge
The same
order.
annexure is impugned in the previous read, my lord.
Right. If there is further development, then he could have also challenged that.
Challenge that.
No issue. But non-challenge has become irrelevant now.
Now the question is, my lord, the order which was passed in 2013 and it remained even till the read petition was preferred, and in the process, my lord, so many years have gone. We do not know what should have been the status of those properties.
You can't act upon this such order. Once annexure 2 foundation goes.
No,
Yes, my lord. The
that
superstructure
foundation
will
has
go.
gone only in 2022. Foundation has gone only in 2022. Whereas the order, the foundation which was there available and has been acted upon.
So what do you propose? Even if High Court set aside annexure 2, annexure
No, no.
5 will survive.
Annexure 2 will never survive. Annexure 2 will never survive.
Dispose कर दଉଛି ନା କାଲି କି ଆଉ କହିବେ ଆପଣ?
Dispose କରିଦିଅନ୍ତୁ.
Had the submission of respective counsels, the petition involved. The challenge to a belatedly challenge to the annexure 5 on the premises that annexure 5 remaining through a foundation at annexure 2, a proceeding were decided by the annexure 2 and annexure, the order by the annexure 2 having been decided in annexure in a writ application by this court in WPC 17321 of 22 and declared bad in law in order by the annexure 5 having foundation through as an outcome of the result by the annexure 2 must fail. It is in this circumstance, counsel, Sri Mahanti learned counsel attempted to draw the attention of this court in the setting aside of annexure 5. Sri Ghosh learned State Counsel, however, in his opposition to the claim of the petitioner contents, in the event, looking to the date of disposal of the proceeding by annexure 5 being 1/6/2013, and the read petition referred to here in read petition WPC 17321 of 22, having been brought on record of the High Court in 22, nothing prevented the petitioner to also assail the outcome, the order by annexure 5 as an outcome of annexure 2, so that the High Court would have been in a position to take decision on both the orders. And it is in this context, Ghosh objects the entertainability of the read petition, while also objecting the entertainability of the read petition on the ground of limitation. Considering the rival contentions of the parties, this court find undisputed fact remain to be the previous read petition WPC number 17321 of 22 involved a challenge to the order in proceeding so and so in annexure 2. Okay, the read petition, in the final part of the order, annexure 2 gave the following direction. This court here find in the challenge to the annexure 2, there is already an outcome by order dated 14/7/22 in WPC 17321 of 22 with the following direction 5 and 6, page 31. It is in this circumstance, this court observed, even though there has been no involvement of the challenge to Annexure 5 in the proceeding initiated in in the year 2022, through the writ petition indicated herein above, once the order at Annexure 2 is set aside by way of a direction of the High Court, any order surfacing pursuant to direction by Annexure 2 doesn't exist, doesn't survive. In this circumstance, this court finds there has been no necessity of challenging Annexure 4 Act. It render infructuous automatically as an outcome of the order of this court in the writ petition. The petition stand disposed with above observation. There is no need of challenging that order.
Because they have more NAC government record.
I have given clarifications, it is more than sufficient. Yes.
Bow down, ma'am.
Item 32.
32 it out hearing.
May I please your lordship?
Fast contempt.
Kal to reference.
Reference or supervisor?
Fast contempt.
My lords.
Order sarla par dekhiba na.
Item 33.
33 रे आउ किछ अछि कि?
Again, so cause file he is Mr. Panda had prepared that so cause. Therefore, I say since he is ill, अपना सोमवार दिन आनिके एटा को डिस्पोज अप करिवे.
आर सप्ताह रे आनिबा गुरुवार दिन. Adjourn on the premises of illness in the council to conduct the case. Place this matter next Thursday.
Item 34.
Item 41.
May I please your lords?
Fast
Item
contempt.
34, fast contempt.
Fast contempt.
Oblige.
Item 35.
Fast contempt.
Fast contempt.
35 fast contempt.
Again.
You are saying 35 रे भवानी शंकर मिश्र. Mr. Ghosh, is this fast contempt?
Fast contempt.
Fast contempt.
Item 36.
Item
36 my lord, fast contempt.
Fast contempt.
Yes.
Okay.
Oblige.
For orders, item 37.
37, my lord, that
7 रे जाइछि कि limitation रे notice.
my lord, as per direction, I have already served the copy on the
You have
council.
solved copy on the other side. So
My
let us restore the matter.
Lord, after your lordship may see.
Okay, down Karan.
Your lordship may see. This court has passed perimetry order. There is delay of 229 days, my lord, in filing the appeal.
I am normally restoring matters. This court records serious objection
I am appealing for OP 2, my
by
lord.
the counsel for the opposite party. Keeping in view the objection raised herein, however, going through the grounds in the CMA appeal, this court find the petitioner able to make out a case for restoration of the arbitration of the arbitration. That is arbitration appeal, no arbitration.
Arbitration appeal 23 of 2018.
Arbitration appeal 23 of 2018. Right. Okay, the CMA appeal stand allowed in the restoration of record कर दो submission of both sides.
Item 38.
Copy दे दी. Copy दे दी.
Well, 38 may kindly
Mr. Verma, आप file करचंदी appearance memo
Yes, ma'am.
ଦେଇचंदी.
Yes.
Okay, Mr. Verma.
My name may be
Banade.
reflected, but that has not been reflected.
All right, yes.
Public.
38.
38 lords may kindly be
Okay,
permitted.
all right, dismiss. Keeping in view the memo.
Item 39.
And 39 for interim.
Application of stay ଆମେ ଗୋଟେ petition ଟା file କରିଥିଲୁ copy ଟା ଦେଇ ଦଉଛୁ ଅବିକା next week ଆସୁ.
And they have also not filed the counter.
ସେଟା ଅଲଗା କଥା.
Counter ବି file ହେଇନି.
Counter ଟା
ତାହେଲେ 2 weeks ପରେ ଆସୁ ଆଉ କାଇଁ?
next week ଆସୁ ତା ଭିତରେ କଣ counter ହେଇଛି ମୁଁ ଦେଖିଦେବି ଟିକେ. ମୁଁ copy ଟା ଆଗ ଦେଇ ଦିଏ ତାଙ୍କୁ.
ଆଉ କାଇଁ ମତେ trouble କରୁଛନ୍ତି? 2 weeks ପରେ ଆସିବ।
ଆସୁ ଆପଣ କରିବେନି କି କରିବେ?
All right, 1 week after. In the meantime, copy of application for vacation of stay is served on the counsel for prisoner. Interim order to continue. Yes,
Item
what is
40.
substitution?
May I please, my lord?
Hmm.
And the original petitioner has been died, and
କାଲି ଶୁକ୍ରବାର ଇଏ ସେଟାରେ କଣ ସବଷ୍ଟିଟ୍ୟୁସନ ଫାଇଲ କରିଛନ୍ତି?
My lord,
କିଏ ମରିଗଲା?
petitioner,
Sole petitioner died.
my lord.
It's an application in the substitution of the sole petitioner. କାଇଁ ଭୋକାଲତନାମା ଦେଇଛନ୍ତି?
My lord,
ଭୋକାଲତନାମା କାଇଁ? ଇଏ ତ ଇଣ୍ଡେକ୍ସ ରହିଲା, ଇଏ ପିଟିସନ ରହିଲା, ଡେଥ ସାର୍ଟିଫିକେଟ ରହିଲା, ଭୋକାଲତନାମା କାଇଁ?
ସାଲା ଆଇଏ ଫାଇଲ କରିଛି ସେଇଥିରେ ଆଇଏ ଫାଇଲ କରି ସେଇଥିରେ ବକାଲତନାମା
ଆଇଏ ରେ ଲାଗିନି ଏଠି। Place the matter next week. Rest is directed to find out the vokalatnama, if any, attached for the substituted LRs in the IA 11492 of 23. Probably you have not filed. Find out from your file. If it is not filed, then file it again. Next week ଆସିବ matter. Yes, hearing ଆଉ କଣ କରିବା? Hearing ହେଇପାରୁନି। ଏଇଟାକୁ ରଖିଦିଅ, ଶୁଣ ଇଏ ଯୋଉଟା ପାସ୍ ଓଭର ହେଇଗଲା ସେଟା ଥାଉ, ଆସିବ ମଙ୍ଗଳବାର। ଆଉ ହିୟରିଂ ହେଇପାରୁନି। ୟା ଦେହରେ ମିଷ୍ଟର ମହାପାତ୍ର ଥିଲା କି ବିଡିଏ ର ମ୍ୟାଟର କିଛି କହୁଥିଲେ କଣ ରହିଯାଇଛି?
ସେଇ ଗୋଟା ଯୋଉଟା ଆଇଟମ ନମ୍ବର ସିଡିଏ ମ୍ୟାଟରଟା, ସେ ଯୋଉ ପଏଣ୍ଟଟା ସେଟା ଆଇଟମ ନମ୍ବର 3 ରେ ଯୋଉଟା ଥିଲା। ଆଇଟମ ନମ୍ବର 3 ଯୋଉଟା ଆପଣ
3 ହେଇକି ଆସିଥିଲା, ଆମେ କହିଥିଲେ ଫ୍ରେଶ ଆଡମିସନ ରେ ଆସିବ। ସୋ ଏଟା ଆସିବ ମଙ୍ଗଳବାର।
ଓନ୍ଲି ଗୋଟେ ଛୋଟିଆ ପ୍ରେୟାର ଅଛି, ସ୍ମଲ ପ୍ରେୟାର ମ୍ୟାଟର।
କୋଉଟାରେ?
ଗୋଟେ ଆଇଟମ 45 that whole total medical clinic has been seized. Counterfeit minors have gone through only 1 point.
କରିବା ମୁଁ କେତେବେଳେ ନେବି କୁହନ୍ତୁ? କାଲି ତ ଆପଣ ମାନଙ୍କ ଦୟାରେ ଆମର ରେଫରେନ୍ସ ହବ।
ଠିକ କଥା।
ଆମେ କାଲି 3ଟା ପରେ ବସି ପାରୁନୁ। ସକାଳେ ତ ଏତେ ହେଭି ମ୍ୟାଟର ରହୁଛି ଯେ ଗୋଟାଏ ପୂର୍ବରୁ ଦେଖୁଛି।
ଆସୁ ଏଟା ମଙ୍ଗଳବାର ଦିନ ଆସୁ ଫ୍ରେଶ।
I find surprise so many councils at this hour.
That is
ଅନ୍ୟ ଜାଗାରେ ତ ଆମେ ଯେତେବେଳେ ରହୁଥିଲୁ 4ଟା ବେଳେ ଆଉ ଗୋଟେ ମ୍ୟାଟର ନେବେ ଚାଲ।
Nothing more to say in that.
କରିବି।
Nothing more to say in that matter.
41
45 may be taken about fresh.
କେସ କୁ ଶୁଣ ଦେଖିଲ ଆଉ ଯୋଉ ଆର ଶୁକ୍ରବାର କେତେଟା ମ୍ୟାଟର ଅଛି? କିଛି ଫିକ୍ସ ହେଇନି। ସୋ ଆସୁ ଏ ମ୍ୟାଟର ଗୁଡାକ ଆର ଶୁକ୍ରବାର ଦେଖିବା।
ଆଜ୍ଞା
ଆର ଶୁକ୍ରବାର ଆସୁ, କିଛି ମ୍ୟାଟର ନାହିଁ।
ନାହିଁ
ଆର ଶୁକ୍ରବାର ଦିନ କିଛି ମ୍ୟାଟର ମୋର ନାହିଁ।
45 ଟା
ସେଦିନ ମୁଁ କେବଳ ହିୟରିଂ ଟେକ୍ ଅପ୍ କରୁଛି, ଭେରି ଫ୍ୟୁ ଆଡମିସନ୍ସ ନଉଛି। ସୋ ଶୁକ୍ରବାରକୁ ରହୁ ଦେଖିବା।
ସେଇ ଦିନକୁ ରହିଯାଉ। 45 ଆଇଟମ
ସବୁ ଏଇ ଯେତିକି ରହିଲା ସବୁ ସେ ଶୁକ୍ରବାର ଆସିବ। ଏ କେବଳ ଏଇଟା କୁହନ୍ତୁ, ଏଇ ଯୋଉ 45 ଟା ବି ରହିଲା ଶୁକ୍ରବାର, ତାହେଲେ ଥାଉ 46 ବି ଶୁକ୍ରବାର ରହିଲା।
ଆଇଟମ 41
ୱିଡ୍ର କରିବେ?
ନା ନେକ୍ସଟ ଡେ
କଣ ହେଲା 41?
ଡାଇରେକ୍ଟ ଇନଷ୍ଟ୍ରକ୍ସନ, ଏଥିରେ ଆମେ ପେମେଣ୍ଟ କରିଦେଇଛୁ, କଣ ଆଲଟମେଣ୍ଟ ହବା କଥା।
ଆରେ ସବୁ ରହିଲା ପୁରା ଶୁକ୍ରବାରକୁ ଦେଖିବା ଆଉ।
3ଟା ମଧ୍ୟ
ଆଉ କଣ ଜଣ ଜଣକୁ କହିବି ରହିଲା ଶୁକ୍ରବାରକୁ ବୋଲି? ଶୁକ୍ରବାରକୁ ଏ ସବୁ ରହିଲା ହେଲା, ଆଉ କିଛି ଆଡ କରିବନି ତା ଦେହରେ। ଆଉ ମତେ ମନେ ପକେଇବ, ମୁଁ ସେଦିନକୁ ଫିକ୍ସ କରିବି। ତାପରେ ତ ମୋର ଆଉ ଗୋଟେ ଦିନ କି 2 ଦିନ ଆଉ। ହଁ
ଆଇଟମ 3ଟା ତାହେଲେ ଆଇଟମ 3ଟା
3ଟା ମଙ୍ଗଳବାର ଆସିବ, ସେଇ ଫ୍ରେଶ ଆଡମିସନ ରେ ଆସିବ।
43 ଟା my lord 43 may not hear.
43 କିଏ କାଉନସିଲ ଅଛନ୍ତି? May not or shall not? Shall not. 43 out of list ହବ। Yes, if I can't hear, what is the next? 43 କିଏ ଅଛନ୍ତି ଦେଖ? 43 will go out of list. I'll not hear. Hello. State Council brings to the notice of the court that this matter cannot be heard by this bench. Okay, this court find in fact this bench cannot hear the matter. Accordingly, direct delisting of the matter and obtaining permission of Hon'Ble Chief Justice be listed before any other activities.
May I request one?
Interim order ଥିଲେ extend କରିବ।
41 ଟା ମଙ୍ଗଳବାର ସାର୍ ଟିକେ ଆସିବେ।